He's talking to the mic. Thank you. You're welcome. Should I say anything else? We live this morning. Test. That's too loud. Try it now. Still kind of loud. All right. I'll just keep it further from my lips. Oh. 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 Okay, we live this morning. Somebody give me the signal when it's time. Okay. All right. Thank you. Well, good morning, everybody. Today is Saturday. The month is October. It's 2022. You know what that means. George W. Crockett Community Law School. An opportunity for all of our folks to get oriented to the law, to try to demystify some of the, I say, street teaching that we hear from time to time. And so we bring you real folks, professionals who are knee deep in the law at various levels to help inform you of what's going on. So George W. Crockett Law School, what is that? That is a part of the Detroit branch NAACP Thurgood Marshall Ruth Bader Ginsburg Legal Initiative. Now that's a mouthful, but just remember the great Thurgood Marshall, first African American Justice of the Supreme Court, great civil rights leader and litigator, and Ruth Bader Ginsburg, great and tremendous woman who was a civil rights icon even before she joined the Supreme Court and continued in that vein throughout the entire time that she was there. So we look at those folks and we say, what can we do to help the regular folks, the average person, the people who aren't lawyers understand the law? We looked at a great man who was George W. Crockett. He was an attorney. He was a civil rights litigator. He was put in jail for defending his clients on civil rights issues. He became a judge here in Detroit. He became a congressman. He's a great individual. So we named the law school after him. Today, you really are in for a treat because first of all, we're going to double up on you initially. We talk all the time about civil rights. Most of us know that in the state of Michigan, there is a Department of Civil Rights within the government, within state government. And that department staffs attorneys, investigators, and other personnel to advance the cause of civil rights. So we got two great people here with us today. First, Valerie Barkley. She's a staff attorney with the Michigan Department of Civil Rights. And I think that one of the greatest things about Valerie is that before she became a staff attorney, she was an investigator at the Department of Civil Rights. Now, investigating means just that, rolling up your sleeve and finding out who's telling the truth, who's not, whether there's a violation of the law, whether there isn't. And I think it's significant that even while she was investigating civil rights complaints, she went to law school, studied, and became an attorney and is now a staff attorney at the Department of Civil Rights. That's just a little bit about her. I'll let her tell you more about herself. Then we've got Todd Walker. Todd is currently an investigator at the Department of Civil Rights. When you hear him speak, you will see and hear that he is passionate about the enforcement of civil rights. But y'all didn't come here today to hear me talk. You came here today. You came here today to hear these wonderful people tell you about the law, the investigation, and the enforcement of the law. So without any further ado, may I ask that Valerie Barkley and Todd Walker please come forward.
today we're going to focus a lot on employment, but I wanted to give you guys an overview that we also cover places of public accommodation, places of public service, education, and housing. The difference between place of public accommodation and public service, those are some of the federal laws that we also help to enforce, but we don't need to get into that. So the distinction between public service and public accommodation, public service is going to be your government entities, your municipalities, whereas public accommodation is going to be places that you patronize, businesses that you go to, different services, different facilities, and things of that nature. So our state law, ELCRA, and Persons with Disabilities Civil Rights Act, the coverage and protection that is afforded to individuals is that you cannot be denied the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations under the law. These laws, as you'll see on the screen in bold, these are the areas that are covered under ELCRA and Persons with Disabilities. Disability, religion, race, color, national origin, age, sex, and marital status. If you fall into any of those categories and have suffered a denial of service or unequal service at a business that you've gone to, sexual harassment, or you're a person with a disability and you were not accommodated, even though you've requested a reasonable accommodation and one was not afforded to you, you may have a complaint to file with our department. Under these state laws, you have 180 days from the date of harm in order to file a complaint. Something else I wanted to bring up in this presentation is law enforcement. Law enforcement issues, namely racial profiling. Oh, hey, I hit the wrong button. Sorry about that. Come on. There we go. So law enforcement racial profiling is probably the biggest area that we see when we get law enforcement complaints. Those also fall under the public service category, so they are investigated under state law. But some of the other areas that we look at under law enforcement can be arrest, tickets, sexual harassment, also failure to accommodate a person's disability. So I wanted to bring that up because it is something that is very relevant and in the law or in the news. Pretty much weekly we see some kind of issue going on. So just so you're aware, that is something that is covered. Okay, just a brief overview of education. So ELCRA and Persons with Disabilities also cover education. So an educational institution cannot discriminate against a person, an individual, in the full utilization of or benefit from the institution, their services, their activities, and their programs because of religion, race, color, national origin, and sex. There's a couple other areas, age and marital status, that are protected during the admissions process. So if you're applying for college or you're applying for, a charter school for your child and they ask about age or marital status, those things can be protected. And this area is also 180 days to file a complaint with our department. Now there's a couple exemptions here. Religious educational institutions are exempt from ELCRA, but not Persons with Disabilities Civil Rights Act. And then private institutions are exempt from ELCRA only as it relates to sex. All right, and then also we cover housing. So we have what we call a work share agreement or contract with HUD, where we can investigate what's called dual file complaints for both our agency and our federal partner. So we enforce ELCRA, Persons with Disabilities Civil Rights Act, and Fair Housing Act, or Title VIII. Under our state law, we have 180 days to file a complaint, whereas the federal law, there's 365 days. So even if your issue falls outside of that 180-day window, but it's within 1 year, you can still contact us and we can still generate that complaint for you and then pass it on over to our partner. The covered areas in housing, and I know you have a wonderful presenter later on today that's going to tell you all about housing, so I'm not going to get into the nitty-gritty of housing, but we cover race, color, religion, sex, including sexual orientation and gender identity, national origin, familial status, and disability. And under state law only, marital status and age are also protected. So now, what we're all here for, employment. So MDCR, similar to our contract with HUD, has a work share agreement with the EEOC, meaning that we can investigate complaints on behalf of both agencies. And why that's significant is, well, one, we know everybody's backlogged these days. Everybody's behind. There's not enough people to do the work. There's not enough money to get the people to do the work. So with these types of partnerships, it's really great because instead of working with 2 investigators and 2 agencies, you work with one that we are similar in nature to what we do. Our laws mirror each other in a very significant way. And so that gives us the ability to not only look at the state law, but look at the issue from the federal law perspective as well. There's a couple distinctions, though, in the employment realm. So under ELCRA and Persons with Disabilities Civil Rights Act, all you need to qualify for an employment complaint is to have 1 employee. That's it, 1 employee. So it can be a very, very small family-owned business. There's only one of you that works there and somebody else owns it. Whereas under Title VII and ADA, you're gonna need 15 employees. So it's gonna be very important for you if you're experiencing an employment-related issue to have an idea of how many employees there are. I mean, obviously, if it's a huge employer and there's 500, 1,000, maybe 10,000, that's gonna be pretty easy to meet that threshold. Whereas, if you work for kind of a smaller place, you'll have to, tell your intake worker about how many people work there so that we know how to generate the appropriate complaint. But at some point later on in our presentation, we are going to explain more about complaint intake and what to expect and kind of what to bring to the table when you're calling us with an issue. The other distinction is under the ADEA, and that requires 20 employees for the federal law. That is your Age Discrimination and Employment Act. All right, so under our state laws, as you see on the slides, there are a bunch of different protected classes: race, religion, color, national origin, sex, and age, disability, genetic information, retaliation, also including marital status, height, weight, and arrest record. That's a lot of different areas that we cover. The reason age has chronological behind it is because in employment, age in the state of Michigan is any age. It doesn't matter. So ELCRA and Persons with Disabilities are going to protect you on any age you are, from infancy to our wonderful elder generation. Whereas the distinction in the federal law is the magic number is 40 plus, so age 40 and above. And as you see in the bold protected classes there under the federal laws, there are a few less areas. So basically, MDCR and the laws that we enforce, our state law, has additional protections in place for citizens. Because of our work share agreement, we have to be very similar situated in the fact that we investigate the same types of protected classes, the same types of reasoning, but we can expand our state laws and include additional protections. We just can't limit those protections and have lesser protections. So, under the state law, we can include marital status, height, weight, and arrest record, where those things are not included in the federal law. So again, with the state law filing, 180 days from the last date of harm. In some instances, you will have like a continuous harm. You will have where, maybe a harassment case or hostile environment case where, the hostile environment begins at one date but continues on for a variety of different dates. So when we say last date of harm, it was, what is your most recent date of harm? When was the last time something happened to you that you believe was discriminatory? And under our federal partners, the federal laws, you have 300 days to file from your last date of harm. So similar to the other area in housing, even if your last date of harm is outside of that 180-day window for MDCR to investigate your complaint, you can still contact us and we can still generate that complaint on behalf of our counterparts and ship that on over to them. All right, so I'm going to get into a couple areas that I think need a little more definition under the employment laws. So sex discrimination. Sex discrimination is very broad, especially under ELCRA, because it is, well, I guess now our federal counterparts have similar protection. So I say that because there's a lot to really think of here. So it is not only just man or woman. It can be non-binary. It can be somebody who is transgender, who is transitioning. It can include pregnancy. It can include sexual harassment. So I'm not going to get into all of the different things, but essentially in 2018, there were some concerns about our Michigan Department of Civil Rights' ability to investigate claims based on sex in sexual orientation and gender identity. And so our Michigan Civil Rights Commission had issued what we call an interpretive statement stating that, yes, these are areas that we can investigate. These are areas that ELCRA, the meaning of sex in ELCRA, allows for these types of complaints to be taken and to be investigated. That was challenged in court. Basically, we were sued, and that was challenged in court. And so I believe it was 2021 where the Court of Claims here in Michigan had ruled that when a person discriminates against someone who identifies with a different gender than the one that was assigned at birth, that is a difference in treatment on the basis of sex and is prohibited under ELCRA. In that same case, the court did not include sexual orientation because of some binding law that was challenged in the Michigan Supreme Court earlier this year. I believe oral arguments were in March, and in July, the Michigan Supreme Court had issued their ruling that sexual orientation is discrimination based on sex, that it is also difference in treatment. So now we align with some of the updated case law that came out of the federal system. So that's a big win for us, by the way. Okay, arrest record. This is particularly interesting to a lot of people, and so I wanted to make sure we had a special slide here. So under ELCRA, employers may not ask an applicant about a misdemeanor arrest that did not result in a conviction. So I'm going to say that again because it is so important. Employers may not ask an applicant about a misdemeanor arrest, so your arrest record that did not result in a conviction. Now, on the flip side, employers may ask about felonies, felony arrests, and things that did not result in a conviction on the felony side of things. But they can also ask and inquire about misdemeanor convictions. So where arrest record is most important is to know that if there was not a conviction, because lots of people get arrested, but then there's never a conviction. There's, charges get dismissed or whatever the case may be. And so just an employer pulling your criminal history, seeing that you were arrested for something, but there was no plea, there was no conviction, the charges were dismissed, they can't use that against you. So that's what's important about our state law. And under the federal law, this is also kind of an interesting piece. Employers are prohibited from treating people with similar criminal records differently because of a protected class. So let's say in the employment world, you have a black applicant and you have a white applicant going for the exact same job. On paper, their qualifications are very similar. Their background checks show very similar criminal history of some sort, yet the employer selects the white applicant instead of the black applicant, and the really only reason is because of the race. That is where this part comes in. So that distinction is really important. And then finally, retaliation. Retaliation is protected under both of our state laws, ELCRA and Person with Disabilities, as well as Title VII and ADA. So retaliation is essentially an adverse action taken against an employee. So you're disciplined, you're discharged, you are demoted, you are no longer allowed to have overtime, but everybody else can because you either engaged in protected activity or you opposed what you thought was a civil rights violation or maybe was a civil rights violation. What we see most often is going to be the engagement in protected activity. An example of that would be Mr. Walker here, my colleague, is investigating an employment-related complaint. A person came to us and said, hey, I was disciplined unfairly. I was disciplined, I believe it's because of my whatever protected class you want to name here. And I think, this person that I work next to could give you some really valuable information about that situation. So we contact that person as a witness. Well, then that gets back to the respondent party or the employer, and now they start taking an adverse action against the person who acted as a witness for us. That's retaliation. Retaliation can be a standalone complaint. It does not need to be linked to a different protected area such as race, religion, color, national origin, sex, and so on. So oftentimes when we're doing our witness interviews, we are letting them know that you are protected for this engagement, for giving us this information that's really valuable to our civil rights complaint that we're investigating. And so if something happens to you from your employer as a result of your engagement in this and giving us this statement, this information, please contact us and file your own retaliation complaint. And also, we sometimes get people that come to us with an employment complaint that says, okay, I'll use discipline again as an example. I was disciplined, I think, I know of another person that I work with of a different protected class than me that didn't receive the same discipline, or their discipline wasn't as harsh as mine, whereas maybe I got a suspension, they got a write-up or a verbal warning. And so, we'll take that complaint and so on. We'll start investigating the complaint. We'll let the employer know, here's the here's the complaint. You have to respond in writing to us, and they will respond. And then something else happens. Oh, closer? Okay. I feel like I'm so loud, and I'm screaming at everybody. I'm sorry. So, okay, well, I will be even louder. I apologize for the folks in the room. So, all right, so back to my example. So we have a claimant that comes to us and says that they have a discipline-related issue because of insert whatever protected class that may apply to you. And during the course of that investigation, something else happens. Maybe instead of a suspension this time, now that the employer knows there's a complaint, you came to us for some assistance, now they fire you. So now we have a discipline complaint, somebody who's now discharged. Guess what? You can come back to the Department of Civil Rights and you can file the second complaint under retaliation. So just wanted to let you know kind of how that works out. Let me see here. All right, and I think I am going to be turning this over. Wait, is this? Nope, that's not you. All right, so sorry about that. Protected employment aspects. So this includes your hiring or application process, as well as when you're already employed. During the application process, if you need a reasonable accommodation for a disability, that area is protected as well. So we also investigate discharge, including constructive. So constructive discharge kind of goes hand in hand with a harassment or hostile work environment complaint, meaning essentially that the employer and the work environment was just so terrible. I mean, it was just so awful that you had no choice. The reasonable person had no choice but to vacate their employment and resign. That's what a constructive discharge is. We look at discipline issues, demotions, unequal wages, failure to promote or transfer, hostile environment, sexual harassment, layoffs, recalls, failure to accommodate disabilities, and unequal terms and conditions. So lots of different areas in which to bring employment complaints. Pretty much anything that you think you're being treated poorly based on a protected reason, call us. Call us, make a complaint. Like I said, Mr. Walker's going to get into how to file a complaint, as one of his skill sets that he brought to the department was intake abilities. And so he was one of our intake workers for a period of time before he promoted to an investigator. So he's going to kind of give you some tips for when you do call us on the types of information that you're going to want to bring forth to help us better service you as a claimant. And then here's just a couple examples of cases that we've actually had that potentially could constitute a violation or something that we would take a complaint on and look into this issue. So here, Paul applies for a position with a large software company. He's informed via email by HR that the company does not provide interpreters for the interview process, but the interviewer will write notes back and forth to communicate. I think what's not said in here is that Paul is a person who is in the deaf, blind, or hard of hearing community. So he is a person with a disability, and during this application process, he's requesting a reasonable accommodation for an interpreter to get through the interview process. And this company is telling him, no, but we will write notes back and forth on a piece of paper. So that could very well be a violation. That is something that we would want to take a look at. So because it's, well, let's just for argument's sake, say it happens within the last 180 days. He's a person with a disability. It's in employment area, and he can give us, his protected class disability. So we can look at that from Persons with Disabilities Civil Rights Act as well as ADA, because our department can investigate claims under ADA in employment. So we would take that because we have a jurisdictional basis, we have a protected class, and we have a timely complaint. So that would be something that Paul would want to contact this department and, go through our process. Something also significant that I did not share with you is at any time during your complaint, no matter what area of complaint it is, you can speak with or consult with private counsel of your choosing and take your claims to court. If it's a state law claim, you have a 3-year statute of limitations to file your claim in state court. If it's a claim that also coincides with federal laws, you can go to federal court and encompass your state claims as well. The one distinction I want to share is in employment, though, for federal court. So in employment, the federal courts require that you have what's called a right to sue notice. That notice is something that can be provided by the EEOC, not MDCR, EEOC. And that notice is going to get you 90 days to file a complaint in federal court on your employment issue. You have to give an administrative agency such as us or the EEOC or a dual file complaint with us and EEOC 180 days to investigate your claim. If you don't give us 180 days to investigate the claim and you withdraw your case and take it to court, or you just file in court and then your investigator would tell you you'd have to withdraw, the court can actually dismiss that claim because you did not exhaust your administrative option. So that's specific to the employment world. So make sure that if you have a complaint that falls under both state and federal law, that you contact our department or EEOC, to at least get that process started. And oftentimes, employment attorneys will make sure that their clients know that you have to start at the administrative level first. So just wanted to make sure I pointed that out because it is extremely important. Okay, so moving on to the next example here. So Kim has worked for her employer for several years. She's got no performance or attendance issues. She learned that a male coworker who performs the same work as her is paid a higher hourly wage. So let's say they're similar in every aspect, that they have the same qualifications, the same performance history, and have been at the same job for about the same amount of time. So that could be an issue that we take. The next one, Robert, an African-American employee, reports that he found an elf on the shelf doll hanging in his cubicle and feels this is offensive and related to his race. This is real life. This has actually happened where an employee went to his office and found an elf on the shelf doll wrapped up in the telephone cord hanging in his cubicle. So he filed a complaint with us. I don't think his name was actually Robert, though. I think we've changed that just to protect the identity of anyone. But he actually filed a complaint with us alleging a hostile work environment based on race. So these things are real situations that have happened, even as egregious as they may seem. Being that we're in 2022, I believe this type of incident happened either in 2020 or 2021, so it is still very prominent out there. All right, next one. On September 11th, Amir's coworkers stopped communicating with him. He overheard coworkers telling jokes about Middle Eastern people and culture. In a similar sense, there was a case not that long ago involving a Middle Eastern individual who was called Shoe Bomber. by some coworkers, and some supervisors had overheard it and then started calling this person shoe bomber as well. So there was a complaint filed on that. All right, and the last example we have for you is Yolanda's supervisor makes sexually charged jokes and comments to other male workers in her presence, even though the comments are not directed at her. That is still something that Yolanda can report and let us take a look at. All right, so I'm going to turn everything over to Mr. Walker, and he's going to walk you through the complaint intake and investigation stages. There you go, sir.
Thank you, Valerie. Okay, so if you believe that your civil rights have been violated, you would contact us. Our offices are currently only open on for appointment only. Complaints can be filed using our online complaint form. You can call our 800 number, or you can email us at mdcrservicecenter@michigan.gov. Virtual intakes are on Monday, 8 a.m. to noon, and Wednesdays, 1 to 5, and it's on a first-come, first-served basis. At this stage, claimants need to provide detailed information about the area, which would be the type of complaint, the date of harm, and the protected class. At this point, we're going to be looking for as much information as possible, information about the respondent, a phone number, address, things like that. If you have witnesses, we would prefer that you have that information available as well at the time of intake. Any emails, any other evidence, you want to let the intake representative know that you have it, so they can document that and the investigator can look out for that during the investigation. Complaints are generated and sent to claimants to sign in the presence of a notary and return to MDCR. So once we do send that complaint out, once we receive it back, we'll process it. It'll be assigned to an investigator who will then investigate the allegations. Referrals. If you contact our department and we don't have jurisdiction in the matter, or you just need some type of other service, we will sometimes refer claimants to the Michigan State Bar for legal advice, a local legal aid, things like that. Department of Wage and Hour if you're having wage and hour issues. So these are different referrals that we will send out, or different agencies we will refer you to. The complaint investigation process. MDCR, we investigate complaints to determine whether unlawful discrimination occurred. A complaint is not a lawsuit. A lot of times we'll be contacted and claimants, they'll be seeking legal advice, or they think that it's a lawsuit. It's not a lawsuit. We do investigate complaints. Sometimes claimants can request a monetary payout, or they can request policy change. They can request apologies, things like that. We don't file lawsuits. While investigating a complaint, MDCR is impartial and does not act as an advocate or a representative from either party. I think Val covered that earlier. We are a neutral agency. We don't act on behalf of the claimant or the respondent. During an investigation, claimant and respondent both present evidence. The claimant equals the person or the entity who files the complaint, and the respondent is the person or entity the complaint is filed against. The claimant, they will have the responsibility to produce evidence, like I stated, and the respondent as well. So the respondent, once they respond back to the allegations, they will a lot of times produce evidence to support their position. In the majority of the cases, the respondent answers the complaint, and then the investigator reviews the answer to the complaint. The claimant provides a rebuttal to the respondent's answer. Based upon the answer and the rebuttal, additional investigation may be necessary to reach a finding. This may include a site visit, interviews, witnesses, and decision makers, and reviewing comparatives and/or analyzing documentation. This is a very important part of the investigation process because we need to have as much evidence, or the claimant would need to have as much evidence to support their allegations as possible, and the respondent would need to provide as much information to refute the claimant's allegations and provide a non-discriminatory reason for its actions. MDCR may schedule a conference with both parties to explore possible resolutions, clarify issues, and/or provide a forum for presenting additional evidence. MDCR can attempt to resolve complaints at all stages of the investigation. If both parties agree to a settlement, MDCR will close the investigation. If no settlement is reached, MDCR will complete the investigation and report its findings. So a lot of times we will attempt to resolve complaints during the investigation process. We want to always keep that option available to our claimants as well as our respondents, because a lot of times respondents will reach out and they will want to resolve the complaint as well. Possible investigation outcomes will be a dismissal. If there's insufficient evidence to support a charge, MDCR will conduct an exit interview with the claimant and dismiss the complaint. The claimant may ask for a reconsideration of this decision. During this time, an exit interview, we'll go over everything that was completed in the investigation. We will let you know the evidence that we found or that we did not find during the investigation. A conciliation can occur if there is sufficient evidence for the filing of a charge of discrimination. The respondent is invited to a conciliation conference and is encouraged to take action to address the discrimination and prevent it from happening again. A charge. If the respondent refuses to address the situation, in conciliation, MDCR may issue a formal charge of discrimination and set a date for a public hearing. During the hearing, an officer will conduct a public hearing of the discrimination charge. All witnesses will testify under oath. The rules of evidence apply, and all the parties have the right to cross-examine witnesses. The hearing officer will decide whether discrimination took place, and if so, what the appropriate penalty should be. Possible investigation outcomes continue. The Civil Rights Commission will review the findings and allow the parties to argue whether they should be adopted. The commission will issue a final order either dismissing the case or requiring corrective action that may include paying damages to the claimant. A claimant or respondent who does not agree with the commission's final order may appeal to the circuit court for review of the case. Filing a discrimination complaint with the Michigan Department of Civil Rights does not prevent a claim from taking legal action in a court of law. We're open for any questions. Our contact information is listed.
Before we take any questions, I want to discuss just a couple of things that Todd made me think about. So during the intake process, as we've kind of been discussing in depth some employment-related issues, some of the really important things that you're going to need to bring to your intake representative are going to be who's the actual employer. A lot of times we get individuals that come to us and say, I'll use McDonald's as an example because we all know what McDonald's is. But McDonald's isn't always a corporate. Sometimes it is a franchise. So somebody may call up and say, hey, I work for McDonald's. Here's the situation that happened. I want to file a complaint. And they're adamant that McDonald's is their employer. So we take the complaint, we get it sent over to McDonald's corporate office, and the response they send to us is, we are not this person's employer. They work for a franchise. So now we're talking, this is weeks to month and a half, into it. Because once we take your complaint, we generate that complaint, we send it to you, you have to sign it in the presence of a notary and return it to us. Then we send it out with a packet of other documentation to the respondent for their written response or proposed resolution. So that mailing system can take a little while. Plus, if it is McDonald's being a very large employer would fall under the federal law too, because they have more than 15 employees or more than 20 if it's an age-related complaint. And so they have 28 days to respond to a complaint. So now we're 2 months and some change potentially into this, and we have nothing. So it's really important if you work for a franchise to know that information. And where you can sometimes find that information is, where does your check come from? What does it say on your check? If it says McDonald's, maybe then you do work for corporate. If it says, I don't know, Kellerman and Associates or something, that is going to be a franchise owner. Additionally, if you work through a temporary agency or a staffing agency, let the worker know that information too, because it could be a situation where we take what's called a companion complaint, one against the staffing agency and one against the employer who had contracted with the agency to bring you in as an employee. We will let them kind of duke it out and figure out who is the potentially responsible or liable party. And there could be a situation where both could be as a joint employer situation. But the more information we have on the front end and in the very beginning, the better off we are, so that, we're not delaying the process any further by having to issue new complaints because we've had a wrong respondent. Also, some of the other things you might want to know or to produce to the intake worker is how much money were you making? How many hours were you working? Are you part of a union? Is there or was there a grievance filed or some internal process to dispute whatever adverse action was taken against you as an employee? So we'll want to know all that information too, because sometimes it doesn't happen often, but sometimes people come to us and say, hey, I have this issue. I lost my job. I was making X amount of money. And so these are the damages that I have because I've been out of work for 4 months, even though I'm really trying hard to find a job. And then as we're getting through the investigation and we get the response from the employer, we find out that they grieved it and went all the way up through arbitration or whatever, and they got back pay for everything. So now we're not going to have much as far as damages, but if there is still, if there's a discriminatory act that has occurred and we find sufficient evidence of that, you're not going to get more money, generally speaking, but we can look at the public interest side of things and, work with the employer to update policies, make sure their policies are compliant with the law, help them find some civil rights training and make sure that all their employees and managers and decision makers are trained in civil rights areas. So, be honest, give us everything you got. These claims, it's the burden of the claimant to produce the evidence necessary. And evidence can be a lot of different things, but written evidence is the best. So you have email chains, you have text messages, you have recordings on your phone, or somehow you get the surveillance recordings from a situation that had occurred. Sometimes employers will write something real silly in your termination letter or something like that. Make sure you save all that stuff and, give it to either intake or the investigator. It's best to give it an intake if you have it, because that will get forwarded, to the investigator, and we'll have it early on before we even have the response, so we can at least become familiar with your side of the story, your version of events. And so once that complaint gets out, the respondent, like I said, in majority of our cases are what we call the dual file claims. So places that have more than 15 or 20 employees and are subject to both state law and federal law. And so they have 28 days to respond to us. Oftentimes, the employers are working through attorneys, and their attorneys request extensions. So sometimes it can be 2-3 months by the time they respond. And then sometimes employers don't respond, and we have to go through an internal enforcement process to get our Attorney General's office, our state Attorney General's office, involved to file necessary court motions to compel the employer to respond to our complaint. That, again, doesn't happen very often, but there is an internal process. So sometimes these cases can take quite a while. It just depends on who's delaying things. Us being a neutral party, we're gathering information from both sides, from claimants and respondents. And so our job is wholly contingent on other people getting us information. So, right now we have a lot of complaints. Our investigators are sitting at somewhere around the 100 complaint range. And that's a lot. That's a lot of people to be dealing with. And it's a balancing act and juggling of various stages of complaints and so on and so forth. As far as investigations go, I want to share some information that may be useful to you, whether you file a complaint or you give some of this information to people that some of your loved ones. But witnesses can be, very impactful in your case, but they can also make or break your case. So make sure that whoever you're offering to us as a witness is somebody that's going to have good information, firsthand, relevant information, things that, I don't want to hear from somebody, oh, hey, this person is a great person. We don't do character witnesses and stuff like that. I need to know the meat and potatoes of what happened, what was going on. Or maybe this witness is somebody that had a very similar situation that occurred, maybe by the same supervisor, and can give us that kind of credible detail as well. Like, hey, you know what? I went through the same type of sexual harassment with this boss, and this is what happened, and this is what happened when I reported it, and that's why this person doesn't want to report it, or whatever the case may be. So make sure, you have really solid witnesses. Get us their contact information. Know what their title is, because we are unable to just go and interview a decision maker. So the person that made the decision to take the adverse action against you, we may have to go through their attorney. If they are the type of person that could put the respondent on the hook for some liability, then and if the respondent is acting through an attorney, we will have to set up interviews through their counsel in order to interview that person. But if it's another hourly employee, your coworker, or even a former employee, if you get us their contact information, we can contact them without going through the employer first. So that is one thing that's crucial to know. Trying to think. As far as comparatives, that's the other thing I wanted to share. Comparative information. These are people that are similarly situated to you, to your job, to everything that was going on there, but of a different protected class. So people come to us and say, hey, you know what, this person that I work next to, they were treated more favorably than me, but then we find out they're of the same protected class. So that's going to kind of, we're going to weigh that out. And it's like, well, whatever your protected class, say you're a woman, this person's a woman. Is it because you're a woman that the employer took this action? Because that's not going to be real telltale if both you and the comparative that you are offering to us to evaluate is of the same protected class. But if you say, hey, you know what? This action, I was disciplined more harshly than my male coworker who's right here, and we did the exact same infraction, but nothing happened to him, and here I got suspended, or whatever the case may be. So, comparatives are really, really helpful, and so, make sure that you have that information, name, title, what happened, if it was around the same time, or from the same occurrence, that's even better. Is there anything else you can think of regarding intake or investigations that just kind of like some tips and tricks? No? All right, well then I guess that's all the kind of tips and tricks I have for you. Do we have any questions?
None in the chat, but I have a question. I know that discrimination in school is one of your top priorities. And I just wanted to know, what's the process for getting people in, and especially when a student has been expelled or don't want to go back to school because this internal investigation is going on.
Okay, so we have a question about education and what our process might look like for a student that was expelled from a school and maybe, has filed some internal complaints or appeals. Bullying, intimidation, stuff like that. So, as I was sharing earlier, we do have some protections in education under ELCRA and Persons with Disabilities Civil Rights Act. So if you are the student and you feel as though you have been discriminated against or subject to a hostile environment because of a protected class, or perhaps you are a parent of a minor child that this is happening to, certainly give us a call, and we will do just as we do with all of our other complaints. We will take a complaint, we will send that to the school district or the school board, whoever the respondent agent would be to discuss that. Usually in a public school setting for minors, or like K through 12, it would be like the superintendent, and then they might loop in the school board and things of that nature, but usually it goes to the superintendent's office. And similar to our employment complaints or our public service and public accommodation complaints, we're gonna generate that complaint, we're gonna get it sent out, they're gonna have to respond back, they're gonna have to give us some supporting information as to why, these actions have occurred. I mean, we don't deal with a ton of education complaints, but we do see them. I mean, even as an investigator, I had some education complaints that were more along the lines of like harsher discipline based on race. Is probably the one that stands out to me the most, is that African American children tend to, or seemingly tend to, get disciplined more harshly than their, white counterparts. And so we would be looking at a variety of different data from the school. What is the demographic makeup of your school? Do you keep statistics on discipline with the children. Do you categorize it by race? What does this look like? Because some schools do keep that type of information. Other schools, I'm not sure, in my experiences, they do have some of that, and we can kind of break it down by percentage and come up with some statistics and look to see if there is a pattern and a practice there that can be discriminatory. So we would also be engaging too and trying to figure out what will resolve your complaint. That may be something that you're asked as early as the intake level. What are you seeking as a resolution to this? What do you want the outcome to be? And so always be keeping that in mind too, because once you make it to the investigator, they can engage in good faith settlement negotiations with the respondent party. So, if you come up with something that seems pretty reasonable, like, hey, I want my student to be able to come to school bully free, and there's a student in this particular class that's really picking on my child, is there any way to move my child out of that class or move this other student out of that class? That seems pretty reasonable. That's something that we would absolutely present to the respondent and say, how can we make this better? The parent has complained to you numerous times, and the situation seems to continue. Maybe it's happening covertly where it's not happening in front of teachers or personnel, and maybe that's why it's continuing to happen and why maybe the school's not getting involved or not doing anything or seemingly doing anything because they're not seeing it. The kid's doing it, on the bus or, nowadays via Snapchat, right? Like everything's occurring online and social media. And Snapchat, those messages delete after, 7 seconds or something, unless you screenshot it and whatever else. So, records of those things kind of disappear into the cloud or the cyber world or whatever it goes to. And so, as a parent, sometimes you're feeling like, what am I supposed to do? You call us. If you feel that it's discriminatory, you call us. We will do what we can to look at both sides of the complaint and make a very neutral finding based on the evidence that's available to us. When it comes to the bullying, we do have an initiative. It used to be called the Relentless Tour. This is something that's part of our education or community engagement division, one of our divisions. We've had a lot of reorganization and people have moved around quite a bit in the last year or so, but we have a staff member who goes out and does presentations for K through 12, and I believe it's called Together United or United Together is the presentation, formerly known as the Relentless Tour. So Anthony Iani, he is the person that presents this information to kids, all about anti-bullying initiative, but he engages with students and discusses all the different protected classes that MDCR is involved with and our laws that we enforce, and he kind of gives them a little overview and goes through an entire, I think it's about an hour presentation too. So that may be something, if you feel like there's some bullying going on in your child's school, you may want to contact our department and find out how to bring that presenter in there to talk to the students. That's always a good way of doing things as well. Another thing. Wow. So what we're hearing from the audience is that there's been an increase or an influx in contacts to this branch regarding education and some racial issues in education complaints, and there were 4 yesterday. So that is really significant. I will share that our department has a crisis response team as well as part of our community engagement staff, that when you have seen some pretty horrific news stories in recent past that have come out involving K through 12 schools, we get involved pretty early on and send representatives to that school to work directly through this process while we are investigating a complaint and trying to figure out what can we do right now to address these issues. Are there internal policies that are outdated, out of whack, or maybe they're perfectly fine policies, but they're not being applied, or they're not being utilized the way they are intended to be utilized. So that's something that not only our investigators would look at, but this crisis response team is part of our community engagement staff. So certainly if you see something that's real big, and, you know, we've seen a few of those in the news over the last few years that have been pretty egregious situations, yeah, get in touch with us and make our community engagement team aware of that. Usually once it breaks the media, we already have some awareness about it. So, all right, any other questions? Chewy.
Yeah, you talked about comparatives, and you said, well, if the person is treated more favorably is of the same class or same protected class, that's an issue. Can you talk about comparatives a little more specifically, because some of the courts are saying now, not only does your comparative have to be different, but they have to have on the same socks you have on and all that. They're really so technical now. Can you go into that?
Okay, so we have a question about comparatives. As we were discussing comparatives, and there's some movement in the courts that comparatives need to be very, very similar, and as my audience member has mentioned, to the point of wearing the same socks. Now, at least at the department level, we will look at comparatives in a variety of ways. And even if your comparative is somebody of the same protected class, that's not it can be problematic, but not necessarily, because just because I'm a woman doesn't mean that I can't treat other women less favorably than I treat men. Just because I'm white doesn't mean that I can't treat other white people in a less favorable manner than people of other races. So we know that discrimination can occur within the same protected class, but oftentimes, or the majority of times, that's not the case. So, we're going to look at the comparative as a whole. When we're talking about the employment sector of our laws and the things we enforce, we're going to look at the people that you bring to us. If you name a couple different comparatives and, they're pretty similar in job duties, and you work at the same location, you work the same shift under the same supervisor, that's going to be pretty comparable for us. And then, what's going to be, I guess, best is if they are in a different protected class, because I think it is harder to prove a claim when they are in the same protected class. But if they're in a different, that can really open your eyes to the potential for there being some discrimination. But again, we're going to look at it as a whole and determine if even the same protected class comparative, if that's an issue or if it's not. We're really looking at the credibility of information and if somebody was treated more favorably than the other. As far as that goes in the courts right now, Chewy, I can't answer that, because unless, we stay pretty up to date on, what our case law is and stuff. And as of right now, that's what we're looking at as a department level, is we're not looking for the exact comparative where you have every single thing, down to the same number of days of service, that you are making the same amount. Like, you could be a brand new employee and you can be a 25-year, senior employee, or whatever the case is. To us, that's still comparative if, you do the same type of work, And there can be situations too where, you work for, let's say, we have a lot of auto manufacturers around here. So let's say you work on the line, but you're under a different team leader than, who you think your comparative is, who has a different team leader. But you guys have the same overall supervisor. The supervisor is the one that took the adverse action. So we'll say, Todd was working on line A under Val as, his team leader, and Chewy was a supervisor. And then we have Marcelina over here on this line, and her team leader is Marlene, but yet they report to Chewy as well. So Todd, he gets to go to break early, he gets to come back late, he gets to play on his cell phone, he gets to violate all the work rules, and his team leader Val does not care, doesn't write him up, just says, when you're on the line, you get the stuff done. I don't give a rip what you do, leaving early, whatever. Just get the parts on the cars, on the trucks, do what you got to do. Whereas Marcelina over here, she had to go to break early, or she had to take a call from her kid or whatever. And Marlene doesn't really care, team leader doesn't care. But then Chewy, on the other hand, Chewy's like, nah, forget you, Marcelina. No, you're getting written up. This is what's happening, don't do it again. Don't let me see that phone out. Another violation is going to be a suspension, but doesn't say anything to Todd. doesn't care that Todd does the exact same thing. So we have Chewy up here as the supervisor who's taking a different adverse action against Marcelina and doing nothing to Todd. So that could be comparable situation, even though they both report to a different team leader. The team leader's not the one taking the action, it's the overall supervisor. Does that give you a little bit better of an illustration? Awesome. Anything else? Yes.
Yeah, thanks for your presentation. It's always very informative. In my experience, there are, well, I just wonder how much the department focuses on mediation. So, in our experience, when we get cases, if there are cases where it's sort of debatable whether or not another lawyer would take the case on and take it to court, but there was something that happened wrong, often we find that that's when an employee may not have lost a lot of money, may have got another job, but there was obvious wrong, so an attorney may not take the case because there's only $15,000 in damages back pay, but there was a violation of the law committed. And I'm wondering if if the department, when it does its investigation, does it try to encourage mediation between the company and the worker instead of just, issuing a report and there's no finding, or maybe it is a finding, but here you go, go forth. Because if you do encourage mediation, that could maybe bring about a result, a more favorable result to that worker, whereas they may not be able to get an attorney in the regular marketplace.
So there is a question about mediation and whether the department ever recommends mediation between the parties. At some point earlier, I don't know, some years ago, I've been with this department for 7 years, and kind of at my onset, we had to dissolve our mediation team. We had a mediation team that would do just that, but due to funding and all that good stuff, we lost it. We're hoping in the future to be able to bring that back, but I say all that because our investigators are permitted to and qualified to engage in resolution discussions. So while it's not a formal mediation per se, if either party presents a resolution to a complaint, no matter what area, it doesn't just have to be employment, can be anywhere, the investigator can, contact the other side, the opposing side, and open up that door for negotiations. We do settle quite a few complaints, and Todd, do you have anything to add as far as, settlements go? What you as an investigator might, be looking for, or how you might facilitate those conversations?
Well, a lot of times, mediation, sometimes we will end up doing mediation, but a lot of times we'll come to a resolution. The respondent or the claimant, they'll come up with something. They'll come up with a policy change. They'll come up with some type of dollar monetary amount. They'll come up with, they may want to move or they want to do something. So we're always looking for a resolution during the complaint process. So we'll always go to the claimant. Even when we take the intake, how do you believe that this matter can be resolved? Because once we get the information for the respondent, we can contact the respondent. Hey, we have this complaint, you've been served. This is how the claimant presents that they want to resolve this complaint. Are you open to that? And then that kind of opens up the dialogue. Then we can kind of go back and forth. So once the respondent and the claimant comes to a decision, then we can close the case. So we're always kind of looking for mediation, but it's not directly mediation like Val said.
We also have a space or an opportunity in the investigation process to conduct what we call a fact-finding or resolution conference. So what that looks like, that would be something set up by the investigator where the investigation is not complete, but that we've identified that this may be an issue that can be resolved. And so we would set up this conference between the parties, try to resolve at the beginning of the conference, try to see if we can settle it. And then if not, then the meeting kind of shifts to a fact finding. So the respondent should be bringing with them, any witnesses that are pertinent, any other information that they, think is going to defend their position. Claimant, same thing. And we're going to, discuss and ask and answer questions of the parties to, help aid the investigation. And a lot of times those fact-finding resolution conferences can be very successful, and oftentimes, once the parties have come together and they know the purpose of the meeting, obviously they want to resolve. So, the the department will try to facilitate those conversations and help, move that process along. So does that help?
Yeah, definitely. And I'm thinking as one other option, is there a chance to refer the charge to EEOC, which does have mediation? So you have the option of fact finding, investigative mediation. But if those don't work out, say we're going to refer this matter to EEOC, they do have mediation department, until you got some more funding.
Right. That doesn't happen often. I would say I've only been aware of, I think, maybe one or two times where something similar has happened, where EEOC has maybe taken jurisdiction of a claim to, go through their process or whatever the case may be. I would say generally we're pretty successful in our resolutions and coming up with, something that makes sense for everybody. And then sometimes we aren't. Sometimes the parties are just too far apart in what they're both seeking. But, that happens. There's nothing we can do about that part. The parties can engage in outside mediation. So if the parties want to pay for their own mediation, they can do that as well. And if they resolve, wonderful, then either you can give us a copy of the settlement and we can close it out as settled, or the claimant can withdraw their claim and we can close it out withdrawn adjusted. So there's a lot of different options and we get creative sometimes. So. And I think there was one more question in the back. Sure. So we have a question about unions and whether or not MDCR is involved in taking complaints that have some union representation or union involvement or subject to collective bargaining agreements. So the answer to that would be yes, absolutely. We have worked so many different employment complaints in which there is a union present. The claimant is a member of the union and is maybe simultaneously going through their union grievance procedure with whatever their issue may or may not be. Sometimes the issue that is grieved by the claimant is not the same issue that they bring to us. So then we're just separate. We're just working, separately. Sometimes, the claimant has grieved not only whatever the adverse action is, but also the discrimination language that's in their contract. That is when it's really helpful, especially when the respondent party says like, oh, we had no notice that, this person is alleging any discrimination and so on and so forth. And we'll be like, yeah, but look at this grievance that clearly says article whatever violation, that they're alleging these things have happened, and they're clearly alleging you and putting on notice that, there's some discrimination that's occurring. So, I worked numbers of cases that had union representation, and oftentimes I would talk to the union representative. Where are you at with your case? What do you think the outcome is going to be in your case? Do you think you're going to resolve it? Because we do have to look at the mitigation of damages. If a person has some potential monetary damages coming to them, but they get a lot of that back through the grievance process, then through our process, we have to essentially deduct it. So, if we have a sufficient evidence finding in one of our cases and say the claim, I'll just throw out a number, is $20,000. Say this person is out, their economic damages are $20,000, and they got $22,000 from, their union grievance, we're not going to be able to really get money damages for them, right? We're just not going to, because we have to essentially deduct that information or deduct that amount. But we could still be looking at policies, procedures, training, all these other different areas. If somebody, was supposed to be promoted or maybe wants to transfer or whatever, we could be looking at that as well. So does that help? Okay, so we have a question and an example regarding the collective bargaining agreement and a union worker or union employee that may be subject to some type of discipline procedure, and if there's a violation of the contract, just how does MDCR kind of sort through some of those issues, and how do we tackle those complaints? So our agency is not in the business of telling somebody how to run their business. We're not going to necessarily enforce your work rules or even your collective bargaining rules. What we're going to look for is whether there was some discrimination based on the different protected classes, that we had gone over earlier. So in your example, you have some line workers, everybody's supposed to be wearing safety goggles. 5 of these employees on this part of the line are not, and then there's 6 people are not. 5 people, nothing happens to, and this one person, the team leader or the supervisor, whoever it is, goes up to that person and says, you need to wear your safety goggles, and really kind of starts picking, and, what does that kind of look like for us? And so, if a claimant comes to us with their complaint, it's timely filed, it's jurisdictional, they have the appropriate, they're alleging a basis that is protected under our laws, that's what we're going to look at. And those other people, are they comparatives? That's what we're going to be looking at. That's what our brain is going to trigger. Why was this one person singled out? What was different about this person, other than the safety goggle thing? Like, again, we're not going to enforce your work rules or your collective bargaining agreement, but if there was some difference in treatment based on a protected class, that's where we get involved. That's what we are looking for. Does that help with the distinction a little bit? Okay. All right. I'm sure our time has got to be up by now. I feel like I've been talking for 2 hours. But we thank you guys so much for being present and learning about us. Certainly, if you have any questions, contact our office. Check out our website. We have a lot of really great information on there. So I'll turn it over to Chewy.
Thank you, Todd and Val. I said Val. I cut it short. See, this is why we're here this morning, because you get so much valuable information. And I like to talk about, they talk about jailhouse lawyers and folks like that, and sometimes they give you really good information. But when you get it right from the source, because what they told you this morning was not only what the law is, but how the law is enforced and how they process things. So that's a tremendous, tremendous asset for us. Well, we're not finished, though. You've had your overview of the Department of Civil Rights. And we're going to have lunch shortly, I think. But I'm going to ask that we keep going. And that when lunch gets here, we'll take a little 5-minute break or something and keep going that way. We have another excellent presenter this morning, having to do with fair housing. And here's what I'm going to ask you to do. Let's take a 2-minute break. For anybody who needs to go to the restroom while we're having our presenter come up, and then I'll introduce him. All right? 2 minutes, please. Hello, everybody, and good morning again. Thank you for coming back promptly. We have again another outstanding presentation coming your way. And let's talk about it for just a minute about what this whole process is about. If you've been with us the last 3 weeks, you've noticed we've dealt with some very fundamental issues that are very basic to all of our lives. We talked about driving. Let me put it this way. There's some things that you always have to have. You've got to have a job, and we just got through talking this morning about employment and discrimination in employment. You got to be able to get to your job, and so a couple of weeks ago we talked about driving while black. And now we're going to talk about another fundamental foundational issue. That is housing. Because when you have a job and you're driving to work, you got to be driving to and from somewhere when you go to work and when you leave from work. You got to have a home. And we all know the history of discrimination in housing. But we're going to get some details about that now. Not only some details about it, but some details about what you can do, what the law provides, and how you can enforce your rights under the law. So Steve Tomkowiak is our presenter this morning. He's the executive director of the Fair Housing Center of Metropolitan Detroit. He's an excellent presenter, not only for us, but he's also served as a course developer and instructor with the U.S. Housing and Urban Development National Fair Housing Training Academy. I'm only telling you that because I want you to know the type of quality that you're in for this morning. Excuse me. You know what that means? That means, Chewy, shut up and let Steve come on up here.
Thanks for the intro. Our office works closely with the Michigan Department of Civil Rights and HUD, and Valerie does a great job as attorney for the Michigan Department of Civil Rights. Todd is a great investigator with the Michigan Department of Civil Rights. You may not know it, but they kind of put their best investigators in the housing unit because of the importance of the issue, and there's higher funding in that. So Todd's all humble in that, but we know what department he's in. It's real important, so I really appreciate what they have to say. And they obviously gave a lot of very helpful information. I'm going to kind of go off script a little bit from the materials that you have. You got materials on overall with fair housing, and then some on reasonable accommodation modifications and things like that. Those are fine, and you can use those materials when those issues come up. But in the kind of the outline or run of show or program has lending discrimination and foreclosure, so I'm going to work, address those issues real quick. And overall, it's going to show just how broad housing is, focusing on lending discrimination, but to see just how broad this is. Just by way of background, the studies show, or statistics show, that there's a great wealth gap between homeowners and renters. Average homeowners, their net worth is in the $400,000 range, about $400,000. Average tenant household wealth assets is about $15,000. You see how important home ownership is for many people. That's their primary asset. Just getting to some of those why home ownership and why we need to develop and what goes on during the lending process. We're going to talk about that. Just a quick overview about our organization. We serve 3 counties. There's fair housing centers that we cover the whole state. Our center only does 3 counties, but yet we have close to 40% of the state population, so we're big in that kind of a sense. We do a lot of fair housing education, training, and outreach. These are the various groups that we train. Since 1977, we were founded about 45 years ago. We received over 8,000 complaints of housing discrimination, over 500 litigations. We had the first lending discrimination complaints, and the total recovery is over 11 million. That's going up, and there's more of a tendency toward non-disclosed settlements. Every year I've been at the Fair Housing Center, there's been 100+ settlement every single year. It just happens. You would think housing discrimination has gone away. It just really hasn't. I'm not saying it's everywhere. There's a number of people, management companies, lenders doing the right thing, but there's still violations, and they're pretty significant. Overall, we attempt to help people obtain housing of their choice without the necessity of litigation. What makes us a little bit different, Valentine made it clear, the Michigan Department of Civil Rights, like HUD, they're a state agency, a government agency, they receive complaints. They're not for the complainant, they're not for the respondent, they're there for the public interest. So they're there to make sure that the interest of the public is served. Our role and our funding is a little bit different. We're an advocacy organization. It's not wrong, we're doing what we're supposed to be doing. We come alongside the person making the complaint and guide and assist them, help them with fact gathering and that. One thing we do, we can send out black-white testers or testers posing with persons with disability and see what's going on within the housing market. Sometimes we do systemic investigations where we initiate investigations of certain segments of the housing market to see what's taking place. So that's a little bit different. We may actually, refer someone to Michigan Department of Civil Rights or HUD, even assist them in that process. We have cooperating attorneys that will take the cases on a contingency basis. So we'll do that as well. There are times where we step in even on regular landlord-tenant matters, habitability issues, and assist people with those as well. Someone called us just yesterday on a lockout. The landlord did not resort to the court process, and the landlord changed the locks. So we'll assist with that. So we're not as strict. Michigan Department of Civil Rights can refer it. They're probably not going to work with that kind of a complaint, or they may go to the State Attorney General's office and refer it that way. We can actually step in and help. There are times I've written up court papers for people, which they filed. I can go into quite a bit of detail with that, but those are just some of the things that we do. We had a emotional support animal case, a bad court of appeals decision. I saw it. I tried to reach the complainant, couldn't reach them. And then finally she contacted our office, so I did a motion for reconsideration to the Court of Appeals, which they denied. So I appealed it to the Michigan Supreme Court, and they granted an oral argument last week. That was a lot of fun. But there's no one that would step in and represent them. So different kind of things that we're able to do. Because we get funding primarily through HUD and other counties, we've gotten funds from Wayne, Oakland, Macomb counties, a number of municipalities in that. MISTA has given us a grant as well. No one who contacts our office is charged, so it's all free of charge. And there's also opportunity for membership or anybody who wants to make contribution. But of course, we're always available to answer questions, 313-579-FAIR, or you can go online, fairhousingdetroit.org. It's kind of warm. Let me put this off for a second. The most recent HMDA data came out in 2021, and I think it came out around March or so. All right, thanks. So what's the status of mortgage lending in Detroit? First thing is there's a non-participation in the market. If you look at the percentage of the black population within Detroit, or even go broader than that on a statewide or nationwide level, there's non-participation. Within Detroit, black population is 77%, but yet only about 47% of the applications. So roughly half people are excluding themselves, right, from the market. There's even, you can look at Detroit, whites are 14%, yet they drive close to 18% of the population of the loan application. So that's fine, a little bit above. Asian is pretty close, but with Hispanic and black, just not applying in a sufficient part. So it tells me that people are just getting kind of accustomed to the same old kind of rental class, permanent underclass of tenants in that. It doesn't need to be that way. There needs to be a real strong emphasis on home ownership. There's a lot of issues that get talked about in terms of public policy. I'm not saying those are not important. They are. Homeownership is so crucial. It correlates with so many other factors like increased educational attainment of children. There's greater health outcomes for families. It stabilizes communities. I mean, it's nothing but good, good, good when it comes to people getting home ownership. Getting financing is obviously a basic part of that. So on the origination rates, you see the same kind of a thing. Again, why I set that context is real clear, because before we even have the discussion about denial rates, we've already have a large percentage of the population that's not even participating. So here we're at a subset of those that do participate in the lending process. You can see for the denial rate, or the origination rates, those are loans that actually close. Within Detroit, for black population, it's only 41.83, or close to 42%. And the United States, overall, it's around 53%. That's still very low. It's still lower than white population, certainly lower than the Asian population. But you can see the problem right there. That is a low origination rate. So what's going on? Borrowers are falling out. Like 60% are not getting their loans originated. And the denial rates go along with that as well. 33% are denied within the city of Detroit. White population is only 16%, and so forth. Lenders are required under the Home Mortgage Disclosure Act to report their loan data by race, ethnicity, and so forth. So this is data that is sent to the federal government. It's compiled, and then it's made available. So you can see the problem. Here's another factor which rarely can, they have lending pattern software. Really easy to crank this data out. Very easy to do. If you need data, we can provide it. We've got a contract, yearly contract to get this data. But even, again, we're talking originations, loans that get originated. Look what's taking place. 23%, these are factors based on the HMDA data, which indicate it's probably a subprime loan. See the problem. 23% are receiving what would appear to be a subprime loan. Lower for white and Asian, and Hispanic is close to the same rate as black applicants. It drops out a little bit within the US, but you see the problem in Detroit. It shouldn't be like this, right? It's a real problem. So these are cumulative things. So anybody who has a discussion about what's taking place within mortgage lending is probably grossly understating the extent of the problem. And whether people want to do something about it, that's another question, right? But it is a problem at every step. Non-participation, then when people finally do apply, low origination rates, high denial rates, high in those that do get originated, high subprime rates. There's also, somebody challenged me one time, said, well, you're hiding information. You didn't put the names down. Well, I didn't put the names down because I don't want to show it, but this shows wide disparities in origination rates. These are, on the software, I can come up with a minimum amount. I did 50 loans because it's hard to get really good data if it's less than 50. But you look at the wild differences. One lender has a 74% origination rate, whereas some at the bottoms are in the 20, even 18% origination rate. Why so different? It could be at the very top with the high percentages, they're cherry picking and not taking applications except for the most qualified people. That's possible. Some with the low origination rates, they could possibly be taking the high qualified applicants and putting them into different loan programs. That's possible as well. So we can't draw definitive conclusions based on this data alone, the percentages alone, but it does indicate that there's a problem. If you go to a lender, you really want to know how they're making their loans in Detroit or Pontiac or Southfield or Bloomfield, whatever area you're looking at, and give the business to the ones that are really originating people and giving people good loan terms. This information is available. This should be something that's readily available for people to look at. I want to say one more thing. I'm going to talk about appraisal, but I'm just going to kind of cut ahead just for a minute because I don't want to go without mentioning it. You need to make sure, we're going to talk about appraisal discrimination in a minute, that any lender you go to, and I'm talking to real estate agents, everybody involved in this process, they need to have a formal appraisal review in place before a loan decision is made. Meaning, if the appraisal comes in low, it can be challenged and reconsidered before a lending decision is made. Many will have a process after the loan decision is made, but by that time the home is probably lost. It has been sold to somebody else. If they don't do it, they're not meeting best practices. Okay, don't go to any lender that doesn't have that kind of process in place. Lenders are reluctant to do it. They need to be nudged and pushed to adopt those kind of appraisal practices. It's ROV, reconsideration of value. ROV is what you should be looking at. Ask them what their ROV policy is. So here real quick, what is fair lending and what are the fair lending laws? There's not really a one fair lending law. There's really no specific fair lending law or fair lending laws. It's a general term that refers to a variety of federal and state laws that prohibit discrimination in lending or discourage unfair or predatory loan practices that target or adversely impact minority communities. And Valerie and Todd mentioned the Elliott Larson and Michigan Persons with Disabilities Civil Rights Act, but the more broader one at the federal level is sections 1981 and 1982, particularly 1982. That prohibits discrimination based on race. It covers whites as well, color, ancestry, ethnic characteristics, alienage status. But it doesn't cover, strictly speaking, national origin. And it covers all these laws, except for the Fair Housing Act, cover residential and commercial properties. There is a problem, there's always been a problem when it comes to discrimination in commercial lending. Doesn't really get the attention that it deserves. Fair Housing Act is restricted just to residential housing, and it has 7 protected class categories that are covered: race, color, national origin, religion, sex, familial status, and handicap is a term they use. The more accepted modern term is disability. Equal Credit Opportunity Act is probably the most foundational law because it covers any kind of a lending transaction, whether it's a credit card, any kind of a loan that's covered under the Equal Credit Opportunity Act. Lenders see themselves subject to the Equal Credit Opportunity Act more than any other law. There's also Regulation B, which really regulates a lot of it, and there's a staff commentary for Regulation B. Just go to the staff commentary for any question when it comes to the Equal Credit Opportunity Act. The thing about Equal Credit Opportunity Act covers race, color, national origin, sex, has marital status like Michigan does. There is no marital status protection under the Fair Housing Act. And then also receipt of any income derived from any public assistance program. If someone's on food stamps or any kind of public assistance benefit, it's protected. It should be taken into consideration as income by a lender. I brought a claim where a lender didn't, the complaint was denied a loss mitigation through the bank, and she was a U of M student pursuing graduate work in social work. And she'd get about $8,000 every 3 or 4 months. Some of that could go to housing. And the lender refused to consider it. Oh, you're not employed, so therefore you can't do a loss mitigation. And so challenge it as a violation of the Equal Credit Opportunity Act. The gentleman asked, I don't know your name, on an employment case, oh, it's $15,000 lost wages, that's not a lot of money, and attorneys won't take it. The same thing comes up in housing cases, but that's not how it works in civil rights claims. If someone has lost wages of $15,000 or has to go get another loan, and say it's minimal, maybe they're paying $50 more a month or something than what they would have been paying. So it looks like it's just a small dollar case, right? But it's not, because you can automatically get emotional distress damages. Goes all the way back to Brown versus Board of Education. If someone has experienced discrimination, emotional distress damages naturally flow from it. So emotional distress damages could be $10,000, $15, $20, $30, $70, $80,000. It's whatever a judge or jury determines. Plus, on top of that, there can be punitive damages, which can easily be 10 times that amount. So if we take the $15,000 in employment case, lost wages, and emotional distress damages, let's do a low amount, $30,000. So we're at 45. And I know in employment, there's caps on punitive damages, compensatory punitive damages. There's no caps in fair housing at all. So in a fair housing case, say it's the out-of-pocket would be, I don't know, 1,000, emotional distress, 30,000. So we're at 31,000. Punitive damages could be 310,000. So you're at what, 341,000 or something. Suddenly it's a big case. And then attorney fees have to be paid by the party that's responsible. They could be 10, 20, 50, $100,000 in attorney fees or more. Very significant. There's a case, American Sign Language case, a jury awarded $1, did not find any compensatory damages, awarded $1 in nominal damages, and there's a pending request for $360,000 for attorney fees. Oh, I'm sorry, and the jury awarded, okay, $1 nominal damages, $100,000 in punitive damages, and a pending request for $360,000. It's a huge mistake to discount the damages in any civil rights case. That's just a complete misunderstanding. We had a case where someone was denied grab bars. She fell, hurt her shoulder, had to have knee surgery as well, hurt her knee and shoulder, and it was a couple $100,000 settlement in a little fair housing case. Right, so don't discount those. And juries, can award it, and they will be upheld because we put a high value on fair housing, a high value on civil rights. That's why courts are willing to recognize, and the reason they award attorney fees is because they recognize the compensatory and punitive damages, especially compensatory damages, can be low in discrimination cases, and that's why they have the attorney fees borne by the party that committed the discrimination. Now, under Elliott Larson, the two Michigan laws, they do not provide for punitive damages. The other laws do. Equal Credit Opportunity Act caps punitives at $10,000. There is no cap for punitive damages under Section 1981 and 1982 or the Fair Housing Act. So it's very significant. When Valerie and Todd, mentioned about how they'll do file a claim with their office, a housing claim with Elliott Larson or Person with Disabilities Civil Rights Act with the Fair Housing Act. It's very important because once the Fair Housing Act claim is there, that case can be pulled into court where punitive damages will become available. You don't get a punitive damages if you go through the Michigan Department of Civil Rights administrative process. No administrative agency can award punitive damages. You have to go into court. So when cases get pulled from the Michigan Department of Civil Rights into court, it's not an insult to their office or what they've done. It's because, the complainants want the full measure of relief that the law provides. Sometimes what the evidence and work that they've done during the investigation process can be very, very helpful to what is then finally shown with the proofs at trial. You don't need to know all the details and all the technicalities of it, but just reach out, and really this is what I'm doing this morning, just to kind of highlight things that will jog your mind to say, you know what, there's a problem occurring here, we need to look further. And make those complaints. You don't have to have absolute rock solid evidence before you make a complaint. Raise it early on. Right? They're nodding their head in the back, right? Because we sit there thinking, man, if people would only just bring these claims to our attention, we could assist. Right? But there's a lot of good claims out there. The misnomer is that people want to bring claims all the time. There are some people that do, but most people just go on with their life and don't want to think about it because it's unpleasant, right? You're not wrong in making a complaint. It's not wrong at all. It's protected activity. So anyways, again, the difference is when it comes to Elliott Larson has age and marital status, which you don't have under the Fair Housing Act. You do have that under the Equal Credit Opportunity Act. So that's the only overlap between them. So it's just a matter of picking which laws would apply. when there's a lending complaint. So here's kind of the way, just examples of what lending discrimination looks like. I always put it into 3 categories. One I call traditional discrimination, discrimination because of someone's protected class or protected status of an applicant or borrower. There's redlining, where discrimination based on the race or ethnicity of a particular community, excluding areas, and reverse redlining, where it's the opposite. Minority communities or minority borrowers are being targeted for unfair predatory loans. Here's one, and this is one where this is a little snippet from the underwriting sheet. It said both borrowers are at an age where retirement is a possibility, so the lender increased their interest rate by 3%. Is that discriminatory? Based on? Age. Is that under the Fair Housing Act or Michigan Elliott Larson or Person with Disabilities, Civil Rights Act? Which law covers age? Yeah, Michigan Elliott Larson Civil Rights Act. What about Equal Credit Opportunity Act? There too? It's got age, right? Age. Provided they have the ability, capacity to contract. A 16-year-old can't bring an age discrimination claim under Equal Credit Opportunity Act. How about a 99-year-old wanting a 30-year mortgage? What do you think about that one? Shaky? I mean, they may raise that as a defense, not likelihood of repayment. I don't know. But again, these were just retired teachers or nearing retirement age. That's not supposed to be counted against them. Somebody had a comment.
No, we had a question in the chat for you.
Good. Yes. Yes, there's subprime lending would be lending that doesn't meet traditional underwriting guidelines. When I say underwriting guidelines, underwriting is the same as risk assessment. When loans are done or when loans are being underwritten or there's been a risk assessment, they do so based on guidelines set in the secondary market. What is likely or what factors are likely to lead to good loan performance? The idea is to make a loan with someone who's reasonably likely to be able to repay. And that would be, well, what kind of a down payment requirement should there be? Or, what should good debt to income ratios be? Or housing expense income ratios? How long should someone be on the job? And the way I kind of do it is this way. If you had to lend your own money out, what would you want the borrower, what would be the qualifications you would like in the borrower? What kind of credit score would you like to see? 650, 700, 750? What kind of down payment? Your money. 10%, 5%, 20%? When I ask people this, they get really, really strict because it's their money. Not because I always want 30% down. I want to make sure that if there's a default, I'm not losing my money. Is that what you think? Yeah. So why are the standards lesser? Because there's a policy to lead to home ownership. That's the goal. Okay, so there's, I can't see that.
Can we take a 5-minute break?
Yeah, let me just finish this one up. So there is, the way to put it this way is this. There's conventional and subprime. Conventional means people meet the conventional Fannie Mae, Freddie Mac, FHA, VA lending guidelines. They're all available online. We'll look at those in a second. And so those would be traditional or conventional lending. If someone for various reasons doesn't meet those guidelines, then they can be put into a subprime or portfolio or different kind of loan programs that are not conventional. Doesn't necessarily mean someone is in a bad loan product. Maybe they're asking for a $5 million loan that's beyond the conventional loan lending guidelines. So here's what you'd have to look. They're difficult cases, but you have to determine, why is someone going into that subprime loan program? Is it being done to take advantage of someone? charge them more fees and costs and a higher interest rate compared to what they should have gotten? And the question is, from lending discrimination standpoint, are they doing it to someone because of their race or ethnicity or their sex or something like that, whereas they're not doing it to other people? And the way you get at, you come up with, the Mishmar Civil Rights can request it and HUD can request it, their loan level data to see how others were treated who have those similar qualifications. It's a lot of work, but it is provable. Right? So if I hear the term subprime, it just, like an off the grid rather than a conventional loan, they're put into a subprime program, may have bad terms and conditions, maybe not. You have to look further with it. But the question is, why? Why is someone being put into a subprime loan program? Well, your debt ratios are too high. There was a thing on Quicken Loans on their website. They said that debt ratios as high as 50% are considered workable or can be worked with by most mortgage professionals. 50%. So you find out if there's non-protected class, non-minority applicants who are getting approved for loans with debt ratios up to 50% or even beyond 50%, then it looks like different people are being treated differently. There was a case you guys, I think, mentioned about people having problems on the job and comparable files. There's a McDonough versus Santa Fe case, Justice Marshall in 1976, something around that time, 1970s. But there were people that were accused of theft on the job. 1 black employees and 2 white employees. The 2 white employees were discharged. The black employee was not. How many comparables do you need? First, Marshall said the anti-discrimination laws protect white and black, so the 2 white employees were protected under Title VII. Then the next question is, well, is that sufficient evidence? All they had was 1 comparable. The black employee that was not discharged for theft, whereas the 2 white employees were. Is that sufficient evidence? Yes. All you need is 1 good comparable. Do you want only 1 or you want more? I'd want more. But if that's all you have, bring that case. It is not only sufficient to state a case, that evidence alone is sufficient to result in a verdict. That's something. On the lending side, there's no 2 loan files or applications that are absolutely identical. It never happens. So they don't insist on exact perfection, same shoe size or whatever. They don't. If they're similar or not similar, really, that's up for the judge or jury to determine. But they don't insist on exact identity because then there would be no discrimination cases, right? On the theft example, well, maybe the black employee took, $250 worth of items and the white employee took $265 worth of items. Is that sufficient to distinguish it? $15? Who knows, right? Those are the facts that go into an investigation, and then the proofs that get presented at trial. Okay? We'll stop here for the moderators till they control the process here. We do what they say. Okay, 5 minutes, then we'll come right back. Thanks. There's a couple videos coming up too, so there's hope.
Okay, we're gonna continue with our fair housing presentation. Let me get the folks back out.
Okay,
Latoya, you can,
bring them in. All right, here's an example of disparate treatment. Two minority applicants were told it would take several hours, require payment of an application fee to determine whether they would qualify. In contrast, loan officer took financial information immediately from non-minority applicants and in a matter of minutes determined that they'd qualify without a fee being paid. Right, that's differential treatment. Disparate treatment would be a violation of Fair Housing Act, Equal Credit Opportunity Act, Michigan Persons with Disabilities Civil Rights Act. This interagency task force on discrimination and lending in 1994 is still good law. The CFPB has reaffirmed it. But that's an example of disparate treatment based on protected class. There's also redlining to the illegal practice of refusing to make residential loans or imposing onerous, adverse terms and conditions on loans because of the predominant race, national origin, et cetera, of the residents of the neighborhood or community where the property is located. It can occur in several different ways. It can be in loan denials, looking at statistical evidence, significant differences in loan approval, denial rates in areas of high concentrations of minority group residents in comparison to areas with relatively low concentrations of minority applicants. There can be discrimination in appraisals. Appraisal more often being a reason for denying a loan in a minority area in comparison to non-minority areas. And there's significant differences in homeowners insurance as well. Areas where homeowners insurance is not being provided. There can be lending discrimination caused by a minimum loan policy, right? And the joint statement talks about a $60,000 minimum loan policy. I've gotten reports in Detroit of people saying lenders applying a $100,000 minimum loan policy, meaning if you're not asking for a loan of $100,000 or more, you don't get the loan. Representative Tlaib was looking at, I think, legislation, I don't know if it got passed yet, but requiring FHA to give some information because they found out that loans under $70,000 were not being made. But if you do these minimum loan policies, there was a Justice Department case of a $400,000 minimum loan policy that would exclude minority areas. That's an example of modern day redlining. Those need to be challenged. And the amazing thing is, you would think someone applying for a $300,000 mortgage and say somebody applying for a $60,000 mortgage, most people think, well, probably the person that's applying for a $300,000 mortgage has a better credit score than someone applying for like a $60,000 mortgage. That's not true. It's not the amount of income that someone has, it's the way they manage their finances. There are a lot of people at very high income levels, but their credit scores are not great. Kind of amazing, isn't it? Some people just live within their means, and others sometimes don't. And so that kind of a thing like that is really probably surprising because we tend to think at the low income levels they're going to be associated with lower credit scores, and that's not always the case. This is a case that we had our office and several other organizations, example of redlining by an a real estate firm, Redfin, had 3 tiers of service. Under $100,000 home list price, no service. Between $100,000 and $200,000, they would refer it to a partner agent, a non-Redfin employee. So they would just do referrals. It would be listed on their website, and they would refer it out. For $200,000 and above, they would give the full Redfin service. They would list the home, sell the home, and give a commission discount. And if you look at that, so we did, examine home listings, and down in the gold at the bottom is where they just didn't serve that area. But in the top, the green area is where they would serve, and the red area is where they basically home listings that were not being offered. And you can see within Detroit, there's Palmer Park, Midtown, downtown, they're making loans, but pretty much not anywhere else in the rest of the city. On the far right side would be Grosse Pointe. Notice in Grosse Pointe, right, loans are being offered, and in Northwest Wayne County, loans are being offered. The gray area is minority community. So you can see their structure based on the list price of the home ends up being a modern day example of redlining. And there's also redlining caused in the appraisal process. In Detroit, collateral is meaning the appraised value of the home. That's one of the reasons, it's listed as a reason, one of the reasons for a loan denial about 20% of the time. Nationwide rate is just 12%. So people have a harder way to go in Detroit when it comes to the appraised value of their home. You would think, well, debt to income, they're low income, high debt. No, it's 19% is a reason for denial in Detroit. Within the whole United States, that's 28% of the time people, that's listed as a reason for denying the home. So you can see the data shows things a little bit different than what you may expect. But again, there's a problem with the way homes are being valued in Detroit. Here's an example. Let me make sure I got my volume on. It's not playing. It may be using the wrong. Yeah, I'm young. It should be playing it. It's still off. That's from current. It should play now, hopefully. You can't hear it? Yeah. I think I need to put it back to the setting here. Sounds like it was playing, but it was playing on mine, not on. Try this one, see if that works. Make sure it's still set. All right, let's see.
Lots of light, water, views, a school right down the hill.
So the house used to end right here.
Owners Paul Austin and Tanisha Tate Austin knew it was worth at least $1.3 million based on a 2019 appraisal. But looking to borrow as the housing market heated up, Paul met a new appraiser and showed her around.
And what was the number value? You open up that piece of paper and what is it?
Oh, $998,000.
Less than $1 million.
Less than $1 million.
Which means almost $400,000 less than
Yes.
the appraisal you'd gotten a year earlier.
Yes.
And so they applied for a new appraisal, but this time
I'm going to guarantee that I'm going to get the appraisal that my house is supposed to get.
And in the United States, what is your best guarantee of getting the best rate possible? Being white.
So they worked to erase themselves from their own home.
All of our art, took that away, pictures of our family. Anything, would resemble that this home belongs to a black family. Just grabbed it all, put it all in the shed, put it all away.
and they asked a white friend to stand in when the new appraiser arrived.
So this time you open the paper and it says what?
1.482.
Yes. $500,000 difference.
Imagine what that money can do for a family. That's seed money for a business. That's a second home you could rent out. That's college tuition. Now, imagine this whole community misses out on those opportunities. It shows that this is a far larger problem than this one address.
Carla Duffy, a homeowner in Indianapolis, told NBC's Priscilla Thompson about using a similar tactic.
I met with two of my girlfriends. Both are married to white men, and I was like, okay, I need to borrow one of y'all husbands.
Her appraisal came back at double the value. A survey of studies of racial disparities in the U.S. mortgage market found that discrimination inhibits upward social mobility of minorities and exacerbates large racial disparities in wealth because home equity is crucial for building wealth. In fact, this community, known as Marin City, was held back for decades. When Paul's family moved here from the South to work in the shipyards, redlining meant it was the only place in the area where African Americans were allowed to buy a home, while white residents could buy and sell anywhere. Today, Marin City's median income is less than $30,000 a year. Neighboring Mill Valley, a mile away, is nearly 3 times that.
In theory, this home should have been your family's escape from that history.
Yes. Right. Yes. Like, we shouldn't had to repeat what my grandparents had to go through, 50 plus years ago. It's frustrating. Yeah. Because we're not as far along in America as we think we are.
The original appraiser did not respond to our request for comment. By the time the Austins got the new appraisal, interest rates and terms meant they couldn't borrow the money they wanted, and they're now suing.
Just the process of appraising is a system that creates inequity in our country.
How do we change the system? Will our story be a catalyst to changing, the system that's negatively affecting Black and brown people every day?
Tom, Paul and Tanisha say that their lawsuit is about the money lost as they were waiting for a second appraisal, but they also say it's about reforming a system that puts the dream of intergenerational wealth into the hands of a possibly biased person. Tom?
So true. Jacob Ward with a very important story tonight. Jacob, thank you.
So this is a pending case we have right now. Retired couple wanting to relocate for medical reasons. They sold their co-op property or contract to sell it for $177,000. Appraisal came in at just $87,000. We assisted them. We got a independent appraisal came in at $255,000, 290% higher. And like Miss McDuffie, they saw a report on MSNBC of a similar case in Indianapolis, and that's what gave them the idea to make the complaint. This is McGuffey's situation. She having a white friend, they call it whitewashing, stand in for her. These are kind of the facts. She bought a home in Indianapolis, minority community, for $100,000. She made renovations, property values increased. Then she did 2 refinance attempts, one with City Side, it appraised at $125,000. Then she went to appraisal, her Freedom Mortgage, which does a lot of FHA loans. They had appraisal network came in. They came in at just $110,000 with a cash out valuation of just $96,000. She waited a few months till her credit, improved from the hits against it, and then whitewashed the home. She didn't disclose her race or gender on the refinance application. She restricted interactions with the appraiser to emails, no phone calls. And she removed photos of anything to show that the home was owned by a Black family. And she had a white friend posing as her brother standing in. When the appraisal was done, the home appraised at $259,000. Right, you see the problem. So there's 2 ways of appraisal discrimination. There's direct, overt, and indirect circumstantial evidence. People have trouble identifying what overt would be. The best source is in the Fannie Mae guidelines. It refers to unacceptable appraisal practices and lender responsibilities. If you just go after individual appraisers, that doesn't solve the problem. Lenders know what's going on. There was a study by Freddie Mac, looked millions of appraisals. They found, again, they had to reduce over a 5-6 year period. They started with 15 million appraisals, but they went down to just 1 million where there were sufficient numbers of appraisers that were appraising homes in minority and non-minority communities. It found that 31% of the appraisers had discrepancies. They were more likely to come in below contract price in Black and Latino neighborhoods as compared to non-Black, non-Latino, or white communities. So it's a big problem with a large number of appraisers, and lenders just let it go with business as usual. It's just a stunning report. Stunning. Lenders know who are coming in low with these appraisals. A contract price is a good measurement of what the home is probably going for. People tend to reach a pretty rough approximation of what the home should be valued at, and that's what they put into their contract. And when the appraisal comes in below, that's a problem, right? So what would be direct evidence of appraisal discrimination? I mean, they're typically not going to write in the appraisal, well, this home by a Black person or it's in a minority community, therefore I'm going to lower the valuation $20,000 or $50,000. They don't do that. What they do say is good neighborhood, desirable location, right? Pride of ownership, no pride of ownership in this community or this home, poor neighborhood, crime-ridden neighborhood. Those are kinds of things. If they're in the appraisal report, that's direct evidence of appraisal discrimination. You just don't tend to see it that much, but those are the factors that you'd want to look at. So for indirect circumstantial evidence, you got to look at where the comps were drawn from, what the distance are, or really the year. I got the pending case, the appraiser went beyond a year, basically, and used lower valuations beyond a year when there were sufficient property sales within that year. That's what led to the lower valuation. Another thing, he excluded another co-op community, which had a higher percentage of white applicants right across the street from where the subject property was. Why did he exclude it? Well, because those tend to always go higher. The reason they went higher is because they allowed financing for those co-op purchases, period. Where they lived, they never allowed financing. People would have to pay cash. That's why the values were lower. As soon as they released that requirement and allowed people to finance their purchases of co-ops, then the value from the ones where they were lower are jumping right back up. They're all over 200,000, on their way to 300,000. So that's factors you look for, and also obtain an independent appraisal. McDuffie then went to the third lender, that's her independent appraisal, which came in at 259. And so those are some of the things you look at in appraisal cases. If there's a problem with the appraised value, challenge it, ask the lender to change it. If they don't, then bring the claim. That's what we did, and she did. And the Detroit couple, they asked the lender to do it. The lender communicated with the appraiser. The lender refused to consider the comparables offered by the homeowners that were looking to sell the home. And the appraiser, and the bank had a, quote, chief appraiser, and they refused to consider the valuation. Does that sound familiar? In almost all the cases, they refused to consider it. Here's discrimination in foreclosure proceedings, loan modification request. You can see the complainant, Brandy Austin. She was $176,000, $176 negative each month after she paid her home, her mortgage, and other living expenses. She asked for a loan modification. She wasn't offered it. Look at some of the other ones. I mean, look at the amount. Upside down, $2,796. I mean, $1,613. You see the amounts that they have. And their principal and interest before modification and after. And here's the principal and interest reduction. Look at these numbers. Right? 782, 988, 755. The interest rate at origination, and then when they received a loan modification, it was just at 2%. This is looking at what? Comparable files. What made these comparables that for her loan modification, she was relying on unemployment income. All these other white applicants or white homeowners were relying on unemployment income. So these are dead-on comparables. That's what it looks like. It's also, so this looks like regular traditional discrimination, a minority being treated less favorable than comparable non-minorities, but there's also evidence of redlining because her location, she's in Detroit, they're in areas that are very highly non-minority. And when you get into the files, it's kind of hard to read it, but this couple had no qualifications at all for a loan modification. They're basically living on a credit card, no income. I mean, it's just amazing. Paying all her bills, here it says here, no longer having the income that she used to make, paying all her bills currently at the regular payment of over $1,400 a month on her primary mortgage, and the rest of her bills has her falling short about $1,700 a month, including 18-month payment on her one credit card. That's it. Okay, she's diligently looking for more income to help in affording her bills, and meanwhile has about 2 months reserves on this credit card to help her in buying her time to supplement income. They got a loan modification. Based on what? Right? That's a dead-on comparable. All you do is present it to a jury. And this is where that home was located. Look at the white population, 97.5. Black population is just 1.6%. This is the kind of evidence that you present in lending discrimination cases. Now there's reverse redlining, where instead of not doing loans in particular areas, right, this one is discrimination where different areas are being targeted. If I back a minute for Ms. McDuffie's situation, is it redlining or regular discrimination? She said she had to whitewash her home. That's traditional discrimination, meaning if there was a white couple or white family in her home, they would have gotten a good appraisal. But because she was minority, she got a low appraisal. That looks like that's traditional discrimination. If it was a redlining situation, it wouldn't matter if it's a white family or black family. If they were trying to come in with low valuations in that predominantly black area of Indianapolis, it wouldn't have mattered what family was in the home, it would have been a low valuation. So sometimes these things kind of overlap a bit. You just get as much facts as you can in order to present it. But it smacks more of traditional discrimination in her situation. So anyways, redlining is the opposite. Areas are being targeted for unfair or predatory loans. This is one, immigrant savings. I'm not going to go into too much detail with it, but it says here more than 75% of immigrants' advertising budget went to 4 newspapers with almost exclusively black or Hispanic readership. Even when controlling for factors like credit score and income, they were 32% more likely to end up in majority African in neighborhoods than similarly situated majority white neighborhoods. So they are focusing all their advertising and marketing toward black and Hispanic borrowers and black and Hispanic community. And really unfair loans, if they fell behind on one payment, automatically increased the interest rate to 18% default interest rate. Basically drove people out of their home. They also targeted homes where there were sufficient large equity in the home, almost like they were planning for a default to occur so that they could take the property back, sell the home, get the benefit from it, right? A jury came up with $950,000 for those 6 families. So it's really crucial to see where are they doing the marketing. Here is another one you can see on reverse redlining is rent-to-own or land contract or contract for deed situations. The seller landlord finances a transaction, he has the deed to secure payment. The buyer does everything, pays rent or payments toward the option, has to pay for the insurance, has to pay for repairs, does everything. And once sufficient title or payments have been made, the seller then delivers the deed. I've never seen this work, not one time. I've seen it work with, if it's a group like Southwest Solutions or some organization is there to make the process works. But individuals by themselves, I've never seen this work, not one time. So there's legitimate, like I said, Southwest Solutions can do it to assist buyers that can't otherwise obtain traditional financing. But it's illegitimate and discriminatory when they target people based on minority communities or people of a certain religious group. They'll target them. And again, it's shifting all the obligations onto the buyer. Inevitably, they're going to default. Also, it violates all the lending laws. There's no Tooth and Lending Act disclosure statement. None of those disclosures are given. Buyers actually have an automatic right to rescind that transaction, but they're not aware of it. It's a disguised financing transaction. Here's another one, this out of Florida, reverse redlining discrimination. Basically would use handwriting kind of communications to make it seem like, well, they're friends and buddies and you can trust them, right? And it urges homeowners to ignore their mortgage company. Don't listen to mortgage company or their attorney, they don't care about you. And here's where discrimination comes in, appealing to naked appeal to racial solidarity. We tell you what they won't. They can't stand to see young brothers doing what they do, right? So they're targeting what? Black community. Their Landover Lending Group was really not there to help people. They overcharge people for foreclosure services and really not provide it. That's, again, they're targeting an area, not redlining it, but it's reverse redlining, targeting an area where minorities live for a predatory foreclosure scheme. Here's another one last real crucial one is discrimination encountered by home buyers is steering. Long Island Divided did a study of this, 3-year investigation from 2016 to 19. 25 testers, trained testers participated, and we recorded the meetings with 93 real estate agents. And they found unequal treatment, 19% against Asians, 39% against Hispanics, 49% against black testers. Believe it or not, close to 50%. Long Island is an affluent, progressive community, but it just, again, they're putting, not all, but many were sending black home buyers, giving them listings in black areas, white, Hispanic, into black or white and Hispanic areas. And some of these statements, in the East Hampton Hispanic community came in and they really took over. They're not allowed to make those kind of statements. Just a short clip and then I'm gonna close.
Yeah. So, 1, 2, 3. My name is Jesus Rivera. Today's the 21st of April.
It's about 10 after 2, and I'm in my car.
So it's Richard Helling testing as Matt Browning on May 3rd.
Hello. Hi. My name is Kelvin too. How you doing? Yes, Kelvin.
How are you?
Yeah, me and my wife is looking to purchase a home within the Brentwood area.
They were ordinary Long Islanders.
Great.
Maybe go get some more then, okay?
And we sent them to meet with real estate agents to ask about buying their first home.
Nice to meet you. Thank you.
Oh, good.
Thank you. I'm David. Thank you.
They were trained, confident, and followed scripts.
Tag in Stephen Macropolis as Nicholas Parisi.
They had no idea what houses agents would suggest, or even which communities.
You were not going to like those schools.
But you don't want to go there. It's a mixed neighborhood.
Mixed neighborhood.
If agents are courteous and professional, how can you know that they're treating you equally compared with someone of a different race or ethnicity?
I have to say it without saying it, you know.
Behind smiles and handshakes, how do you know if they're giving you fewer options or suggesting different areas?
I'm not going to send you anything you want to get, unless you don't want to start your car to buy your crap.
Or that rules don't apply to you and another home buyer in the same way.
Yeah, okay, I definitely need that.
Long Island is one of America's most segregated suburbs. Newsday set out to discover what role real estate agents might play in keeping it that way, potentially affecting the quality of lives.
Technically, as a real estate agent, we shouldn't tell the buyers.
In house hunting, it's nearly impossible to see evidence of hidden discrimination. You would never know unless you go undercover.
In one test, Johnny Mae Alston was the black tester and Cindy Parry was the white tester. And they met with
Anne-Marie Quealy-Bichon at Signature Premier Properties office in Cold Spring Harbor.
They asked for the same thing. As often happens, the agent discussed getting pre-qualified or pre-approved for a mortgage by a bank, showing how much a buyer can spend on a house.
You pre-qualified, I asked. My husband's working with somebody in a bank. We've done some preliminary talks, about getting pre-approval.
Neither had been pre-approved or pre-qualified. Here's what the agent told the black tester.
So I really need that. I won't take out any money unless you have a pre-qualification letter. So I need to know that means I can't pre-qualify for a mortgage.
Oh, so that means I can't go out to see anything.
I won't do it. You can try another person, but I don't have the time.
And without pre-approval, here's what the agent told the white tester.
What is your availability? When can you start looking at houses? I would say not this coming week.
Cindy received 79 listings from this agent. Johnny Mae couldn't get any listings. And Cindy, the white tester, received 2 home tours. They had the same finances, the same budget, and they made the same request in the same area. But one was white, the other was black. The agent treated them differently. Quealy Bichon did not respond to a letter, calls, and emails. Her agency, Signature Premier Properties co-owner and 2 branch managers viewed the recordings and declined to comment.
A 3-year undercover Newsday investigation revealed evidence of widespread hidden discrimination by real estate agents brokering home sales across Long Island. For Hispanic home seekers, evidence of unfair treatment emerged 39% of the time. For Asians, the rate was 19%. Black house hunters in the investigation risked unequal, lesser access to homes and communities just about half the time when compared to white buyers.
Kelvin Toon is a black man in his early 50s, and he went in to meet with an agent involving a test in the Brentwood community, a community that is 80% Hispanic and black. The agent communicated to Kelvin, our black tester, that she enjoyed meeting with clients from the Brentwood area.
Every time I get a new listing in Brentwood or a new client, I get so excited because they're the nicest people.
When we sent Kelvin's counterpart in to meet with the same agent, the white tester was actually warned about Brentwood not being a nice place.
The nursing home we need to be near is in Brentwood.
Okay.
And so we found a couple that are in Brentwood.
Pretty close to each other.
Okay. And it just seemed like those would be handy also for going to visit.
Do you want to give me them and I'll look into them for you? Or?
Yeah, I can do that.
That warning came later to the white testers saying there was concern about gang activity going on in Brentwood. This agent wanted the white tester to know, but that information wasn't provided to Kelvin, the black tester. The listings centered black tester Kelvin in Brentwood with 27 house listings, while the white tester got 0 listings in Brentwood and was directed towards much whiter neighborhoods.
Then this mapping is what proves this. They map the listings. And there's, they show later, they'll show an example of another white real estate agent and gave the same type of listings to white testers in the same area. A good cross-section. He did the right thing because he felt that's the right thing to do. He wasn't going to be treating customers differently because of their color. Right? That's how it's supposed to be. This alone proves discrimination. They have to make the same listings available to everybody. Whose decision is where to live? The buyers. Common sense. We had a case where actually the loan officer was steering testers. And I would say this is not an aberration. I have 2 news clips, like Channel 7 and Channel 4 from our office did the same thing, recorded interactions with real estate agent, one in the 1990-something, whatever, the other one is in the early 2000s, where same thing, discrimination was close to 50%. Again, this was our community. So it's really, really unfortunate. Yeah, question? Yes. Valerie, I think you guys are doing those cases as well. Yes, that's a major problem. Detroit has a fair chance ordinance. There's a lot of non-compliance with that, but there's also, HUD has a 2016 Office of General Counsel guidance on discrimination against people based on criminal record. The adult male population, black male population, 33%, around 33% have a felony in their background. Statistically, everything shows that after 2, 3, 4, 5 years goes by and people stop picking up cases, they're fined, they're no more likely to engage in criminal activity than the general public. We had a case out of Madison Heights. A gentleman was locked up. I don't know exactly what the crime was, but it was a dangerous crime. He was locked up for about 5-6 years or so in the prison. He got out in 1980, 1981, went to Wayne State, got a degree, got out in 1985 or 86, then worked for the state of Michigan for 6 years, continued to work through his adult life. And then in 2019, again about 30-some years later, he went to go rent a unit, I think it's 62 and over housing in Madison Heights, and he was turned down because of his felony background. Okay, if you apply blanket bans, it's going to have an adverse impact on Black, Hispanic community. In our area here, it's going to be primarily Black community, and that's what discrimination looks like. There's nothing at all dangerous about that man. So we have a number of cases where they're doing that. Yes, it still goes on. We have one where I think the attorney is based out of Kalamazoo, whatever, but gave us a recording, and they said, well, we have to turn, it's right in the recording, it's a pending case. We have to turn people down with a criminal record because the HUD rules require it. Well, they don't, but that's what she is telling people on the phone. And so we send testers out there. The difficulty we're finding with these is that management companies, property owners are then sending it out to a third-party company that runs the credit report, rental, or rental history report, and criminal record report, and then they're just giving a yes or no answer. So it's hard for us, we can't test those companies. So what we have to do is first get the complaint where someone, then we examine someone's criminal record to see if they should have been approved, and then we have to make a complaint to the Michigan Department of Civil Rights who they can then get those records. We can't force people to give us records. But yes, those are very important cases. Yeah.
I'm glad you mentioned that. My name is Tara Brown, and I'm actually the one that you all have used a few times for the screening reports example.
Yeah.
And I've sent people over to your office about that same thing, and they're not getting calls back.
All right, let me know who they are, okay?
Yeah.
Yeah, they should be.
I like the presentation you gave, but I look around this room, and most of us are Black. We know this stuff happens. It's happening to us right here in Detroit, and we reach out to the Fair Housing Department and the Civil Rights Agency, and we're left in the lurch if anybody decides to answer the phone. And I think part of that is because I look at what your boards are made of and most of your staff, and they aren't people that look like us. There are no people with lived experience or age experience. It's not diverse other than Black or white. And diversity is something more than Black and white. It's transgender people. It's people of various ages. And again, if we're going to fix these kind of problems, it starts with y'all. It starts with complaints that don't go lingering on for years and years and years. I'm glad that both of you are here because I've made a complaint to both of y'all and they just kind of lingered on and on and on. And I work with Detroit Eviction Defense. I know people are coming to y'all about these complaints. However, it seems like if they're not the right age, not articulate enough, not redeemably respectable, their complaints just kind of linger or they don't get the attention that they deserve. And I'm glad you brought up the thing about people returning from prison because these are not people, I presume, that are sex offenders that he's talking about. These are people that made stupid, simple mistakes, maybe made big mistakes. But like you said, they're 30 years ago. I mean, something needs to be done. Somebody needs to be made an example of so that people, especially here in Detroit, know that that's not something that they should be doing.
Yeah, listen, I'm not going to go into any detail with it. You may not recall speaking to me in all the records that did I not pull a lot of records, a ton of records. Okay, I'll leave it at that.
And I'll leave it at that too because I called you several times since then. And
Okay, I'll leave it at that, yes.
Thank you so much, Steve. And Tara, thank you. What you highlight is the reason we're having these types of conversations because as African Americans, we do live this reality.
Yeah.
But let me say this, we still have to review the data regularly, and hopefully you can our commitment to be a part of the solution. So
absolutely, and I hope we get more of the Detroit data because Detroit
let me just finish. So I'm glad you're here, and I would recommend to Attorney Crockett put her on the panel.
It's both. There's a formal mechanism, dissimilarity index, with 100% perfect segregation and 0% zero segregation. So it's Detroit metropolitan community regularly is in the top 5, and we're still there. But I think, again, it's almost like going into the lending data. It understates the extent of the problem. Here's why. Southfield looks like it's very integrated, but yet if you drill down by school district, you find out, well, Southfield really isn't that desegregated. That's a problem. And another factor is, believe it or not, from 2010 to 2020, our segregation index is increasing, not decreasing. Royal Oak went from 3% black to 1.5% black. Now, even with that percent, what do you think the likelihood of a black person living in Royal Oak as a homeowner as opposed to a tenant? Okay, so we got a problem. So I'm not going to deny that at all. And I don't think people drill down enough to really see the extent of the problem. Right? So yeah, it's a problem. Just recognize the signs of discrimination. I'm not going to go through it, but absolutely gather up all your evidence. Anything you can get, copies of appraisals, records, loan, anything. Obtain that, please. Right? And Valerie will tell you the same thing. Right? The more information you get up front really helps, guides us in that process. Yeah, but I gotta say this too. If anybody calls our office, I got my cards here, and you don't get a prompt response, call me. Please do. Do not leave it at that. I'm the director, call me. That very is concerning about it. I do run the numbers, and if they're down, the complaints are down, or the intakes are down, I'm not happy about that, period. I know what the numbers should be, and I don't tolerate, unless the community suddenly, metropolitan Detroit has become a no discrimination community, or all the habitability concerns have been addressed, which they've not been, we should not be having a drop-off. And I'll leave it at that. So I share your concern, and no one should, and I think the Michigan Department of Civil Rights should feel the same way. Yeah. Yes.
Well, let's thank Steve Kowiak. Great presentation.
I do a lot of training on criminal record. A lot. Okay? There's a lot.
He also does training on expungements, which we also do. So keep that in mind, because we can make a criminal record non-public, which means then that housing folks will not be able to see it. We here at the Detroit branch NAACP, we do expungement 365 days out of the year. So don't hesitate to refer people over who need to get that record non-private.
Yeah, I think mentioned it, and I put Chewy's presentation on expungements on our website. It was such a great presentation. And the stunning part is there's no federal expungement, which I find unbelievable.
Well, there is, if you're close to the president. He calls it a pardon. Just ask Mike Flynn and some of those other folks.
But I appreciate the work the NAACP is doing for that. That's a real quick fix for a lot of people. Okay. Thanks.
Is this your bag? Again, we want to thank all of you. It ain't over. It ain't over. Y'all getting ready to hear something very dynamic
It ain't over. Let's take a 3-minute break. Last time was 2 minutes. Let's do 3 minutes this time. For anybody that
this opportunity to talk about something that's near and dear, probably a cornerstone to all of the things that I care about. And this is really one issue. Democracy, elections, and voting are all connected. Special salute to Chewy K. Believe it or not, Chewy K and I got way over 30 years. We were Optimist brothers together way back in the 80s. I was a teeny bopper. He was much older than me then. But he has always been solid in his commitment to community building and our commitment to self-determination. So I applaud you. I think the best decision the NAACP has ever made was to get you on the staff. So we appreciate you, sir. Thank you so much. Lori Moore continues to evolve. I appreciate you, just solid as an administrator. Appreciate you, Lori, for making all these things happen. And I'm in trouble because I see a lot of members of the staff, and I'm not gonna call each of your names, but I know what it takes to make things happen around here, so special thanks. So I'm gonna talk a little bit about democracy, elections, and voting. Steve, man, you're awesome. Because not only did you bring the data, but I felt your heart. You know, it is not enough to just articulate the data, but there is something very special in this type of advocacy work when you believe in the work that you're doing. And like your predecessor, Cliff Schrupp, I appreciate you. And I'm a solid advocate. I think we need a whole bunch of white Martin Luther Kings. I think 80% of the racism we live is when white folks speak up. I agree with you, Tara. We live this stuff. We know it. But it is important that our advocacy priorities be research-based. But Chewy and I, we've had these ongoing conversations. I look at how white folks skirt the rules, how systems are connected. You guys know I'm a lifelong student, right? I'm always taking a class. So I've got a class right now entitled Law in the African American Experience. And Chewy, you could teach that class. But it's interesting how courts keep changing the rules. Now they have something, I mean, they've had it for years called strict scrutiny. Police have a rule called qualified immunity. So it means when you mistreat black people, there's a rule that protects you. If you're a police officer and you kill somebody, there's a rule that protects you. If you are a court officer or you deliver a court opinion and it doesn't go far enough, there's a rule that protects you. White folk, they keep changing the rules to protect themselves. This whole American experience is really built around white privilege. And black folk, we're just happy to be here, lucky to be here almost. But where we live should not determine if we live or die or have access to opportunity. We know that. But we know that reality is ours. So resilience and commitment to self-determination has to remain a priority for us with no apology, But because all of these systems are connected. The criminal justice experience, I'm gonna touch upon it in a minute, but police and prosecutors and judges, guess what? They're all friends. They know each other. You ever go to a court experience and you got a defense attorney who's friends with the prosecutor, who both have a drink later with the judge? It's all connected. It's the same thing. Realtors, Steve, to your point, realtors and appraisers and bankers and developers, they're all friends. They live in the same neighborhoods. They live in those exclusive subdivisions where you can't live. They make decisions in the backyard, over the fence, at a barbecue. You talk about systemic politicians and legislators and you think the governor and legislators and courts are not connected? You think Gretchen Whitmer don't know Richard Bernstein and don't know the Speaker of the House? All of them are friends. They know each other. So I am suggesting that we got to get in the game. Even prisons. You think legislators don't know the bottom line economic impact of a prison in their district? And you think businesses don't appreciate what a legislator will do to make sure prisons get to those certain districts? Businesses, legislators, and prisons, they're all connected is what I'm saying to you. So where we live very often determines if we live or die or have access to opportunity. Let me just go into this presentation. Feel free to jump in, stop, or ask a question at any point. Jermaine just told me how to be a technology wizard. He gave me something here. He says, push this arrow. We're going to see what happens. So, okay, push this arrow. He said, push up, down. Do I point it at the computer? Okay, I'm pushing it, Jermaine. It worked for you. I saw it work for you. So I'm going to talk briefly about democracy, elections, and voting. But it just worked for you. Oh, you had to turn it on? That helps. It was working for you, right? Or I can do it on the I can do it on the laptop. Go scroll down. Oh, right there. Latoya is the one that loaded it up. Oh, there it is. Okay. So I can do touch right there. Okay. Let me see. Wait. Okay. Let me go back. Let me go back. Okay. All right. We're talking about democracy, elections, and voting, but I always think it's important that we bring historic perspective. And what I've learned is that there are very often things we just don't know that we don't know about ourselves. And let me start with Africa in particular. What do you know about Africa? Or do you think the African-American experience began with slavery? Do you know that we were kings and queens and scientists and all of the above? But who knows what Zinjanthropus boise means? That's the third concept sitting there. What does that mean? Anybody? I'm not putting you on the spot, but somebody better answer. I'm going to call you out. If you took African-American history in high school, you should know what Zinjanthropus boise. Anybody know, anybody ever heard the reference to the oldest fossils? The Oduve Gorge? What that really stands for is the next bullet point that says Africa is the cradle of civilization. All of life, all of humanity started in Africa. Do you know that? About yourself? That's especially significant. Anybody know, most of us know how many countries we have in Africa. All of you know that we have exactly 54 countries, right? But how many of you knew that we had over 3,000 tribes and we speak over 2,000 different languages? How many of you knew that? And not to put you on the spot, just a nugget of enlightenment. And there are certain things we just don't always know that we don't know. And I'm going backwards. Let me click on forward and see what happens. There you go. So what was going on in America? And all of this is a precursor to a quick discussion about voting and elections. What was going on in America between 1619 and 1865? Slavery, which included degradation and brutality. Many of us were treated worse than animals. Worse than animals, no connection to humanity. We were chattel. But, you know, we talk about the degradation of slavery, but we don't talk about the resilience. Black folk were fighting throughout that whole 250 years. Who's Toussaint Overture? What country? Who is it? Haiti. What's especially significant about Haiti? He saved America. That's the rest of the story. How you doing? But do you know the one place in America, the one place in the world where slavery was ended because of black people standing up was Haiti. That's the only place in the world where slavery ended because black people fought back. Did you know that? And to this day, Haiti continues to be punished for that. You knew that too. Sojourner Truth, who was she? Anybody know? Just one or two quick things about her. I am saying people that were fighting back. We talk about the degradation of slavery, but we don't talk about the resilience of our people. These are people that were fighting back. Anybody know who Nat Turner was? And I'm not just putting you on the spot, but I just want you to go a little deeper. African and African-American history is much deeper than just the brutality and degradation. It's about resilience. It's about people who stepped up to their light and they lived their power. They refused We've always been in resistance. We didn't just lay down. And everybody knows the Harriet Tubman story, right? So I just want to touch that. What was going on in America from 1865 to the 1960s? Jim Crow, that's especially significant. So even after slavery, we had another 100 years of second-class citizenship. So I'm leading up to voting and why this is so significant. Black folk, we just won the right to vote at the end of that 100 year. When did black folk become citizens? Anybody remember which amendment? That's so important too, because the Emancipation Proclamation and the 14th Amendment did not happen at the same time, right? And do you know that the Emancipation Proclamation really only affected, first of all, Abraham Lincoln was president of what? Remember the country was split? It was split between what? The Union and the Confederacy. Abraham Lincoln was president of which one? The Union. The Emancipation Proclamation only spoke to slaves in the Confederacy. He didn't even have the authority to free those slaves. Did you know that? Jump into it.
Abraham Lincoln was an advocate of slavery for his entire life until he realized
it became
he couldn't win the war
it became leverage.
without freeing the slaves in the South.
That's exact. And those slaves he freed in the South became members of the Union Army, which made the difference. That's especially significant that we know the truth. And there's this debate going on now about critical race theory. There's some people that don't ever want you to know the truth about who you are and how you got to this moment. But there's something else called the Freedmen's Bureau. Anybody know what that was? After the Emancipation Proclamation, there was an official federal government agency whose responsibility was to connect freed slaves to resources, help them put their families back together. You remember the 40 acres and the mule? All of that was a deliverable of the Freedmen's Bureau. Anybody know how long that lasted? 7 years before it was negotiated away politically. But then you see Freedom's First Generation. This is resilience. These were black folk. This is where Howard University was born. This is where black colleges and black schools and black families, Freedom's First Generation were your ancestors, people you're related to, who went above and beyond to go and find their wives and go and find their children and put their families and put their communities back together. Resilience, fighting back. But at the same time, as the Emancipation Proclamation and the 14th and 15th Amendment was being implemented, there was terrorism, KKK. They've always been around. Their job was to keep you in that second-class citizen experience. But then in the early 1900s, many other formal solutions, NACP, fraternities, sororities, and then as we got to the 60s, that's Emmett Till. Anybody really know what was the Emmett Till story and why was that significant? All of this is a precursor to voting rights, but it set the tone in America. It set the tone in America. So if you really put this thing in numerical perspective, 1695 to 1865, that's roughly 250 years. 1865 to 1965, that's another 100 years. 1965 to today, that's only about 55 years of something else. That's only 55 years or so of something else. And these are reasons to celebrate who you are and our resilience. I always like to highlight these intellectual movements. All of you know who these people are, but these are people who were able to rise above the racism, the sting of degradation, and help build these movements. Everybody know who Marcus Garvey was, right? But do you really know what he had to overcome to lead a movement that embraced Pan-Africanism? Everybody knows Martin Luther King for civil rights. You know Elijah Muhammad for religious freedom. Because before Elijah Muhammad, most of us were what? Baptists or AME? You follow me? I am saying we've got reasons to celebrate. Anybody know who Maulanga Karenga is? Kwanzaa. Another African word for Kwanzaa is Kawaida. And this whole concept of Afrocentricity, Molefe Kiti Asante is a college professor at University of California, Berkeley, He says an Afrocentricity, that as black people, we should measure our lives based on who we are. It is okay to celebrate your ancestry. It is okay, believe it or not. If I go into an Irish person's household, typically you see solid evidence of Irish culture. If you go into a Jewish person's household, you typically see solid evidence of Jewish culture. Very often when you go into African American people's households, you see solid evidence of everybody's culture but theirs. Because we don't understand the value and the power of being Afrocentric. And I just described, these are the faces of the movements that I just described. And now I want to get right here. Now, when did the voting rights become reality? 1965. What were some of the other highlights of the civil rights movement? What other significant acts, laws were passed? Steve just referenced one. It was significant for black folk. Fair Housing Act, what year? 68. My man, boy, you were, my man, it's always good to have a Chewy K.
But listen to this, though.
Yes.
Fair Housing Act was first introduced in Congress in what, 64?
Way, yeah, no question. Take years for this stuff to become reality.
Why did it become reality?
Okay, that's
Because Martin Luther King Jr. was assassinated.
that is so very true. It was a consolation. It was a
week after he got.
That's when they passed. That's so true. Steve, you were gonna add?
Oh, yeah, I mean, Title VII, Civil Rights Act, 64, and then Title VIII is fair housing.
It's fair housing. So this is especially significant because much of what we're debating today relevant to voting and voting rights and voter suppression has its roots right back into this era. So 1968, we just described Fair Housing Act, 1965 Voting Rights Act. What were one or two other significant acts that changed America? What was fair accommodations? What was public accommodation? What year was that? What? Yeah, that's true, but in the 60s in particular, because it's typically these civil rights laws that became the height of what we refer to as the civil rights era. You follow me? And most folks say, well, after we got the 1964, the 1965 Voting Rights Act, the 1968 Fair Housing Act, people say that basically concluded the civil rights era. 1964 was public accommodations. If you're old enough, there's only maybe one or two of you old enough to remember this, but I remember as a child when my parents drove back and forth to Mississippi, we dare not stop. We had chicken and pound cake in a shoebox up under the front seat because we knew that if you dare stop at a restaurant or a restroom, you could be putting your life at risk. So it was the 1964 Public Accommodation Act that began to change the landscape. And then, but all along the way, white folk and business owners knew the economic bottom line benefit of black dollars. And most of the protests in the South in particular, they were put down because white business owners would file lawsuits against the leaders of the protest saying, you're costing our bottom line. The bus segregation was resolved for financial reasons because those private bus companies were saying, hey, we need these black people to ride our buses because if they choose to walk 3-4 miles to work or to school, it's at the expense of our bottom line. I am saying, black people, you got way more reasons to celebrate resilience than we tend to understand. And let's be clear about a couple of things. Power. You don't have it if you don't use it. And why do we come together regularly like this to beg our community to go to the polls and vote? What is wrong with us? What is going on in our hearts that we don't recognize or appreciate the impact of power? I think prayer, I'm not a preacher, so don't get scared, but I do love preachers. But I think prayer is our deepest power. I think that's our deepest power. I think a great education or a good education or any kind of education is your next most significant power, just the ability to think and figure stuff out. I think business ownership is a source of power. But I think one of your most significant power sources is voting. But we're in a new place. So Barack Obama changed the political landscape forever. Did you notice the proliferation and the expansion of overt racism all across this country after the election? You notice black people started getting killed openly by police. This was a conscious act of defiance. Police departments said, "Won't give a damn who the president is. I'm gonna kill me a Negro." And I've got this thing called qualified immunity. I got friends in high places. I know I ain't going to jail. Since Trayvon Martin, for example, over 500 black men have been shot or killed by police. And the fact that we don't know that is because we've sort of reduced this in our consciousness to business as usual. And that means you wallow in a place called hopelessness. You don't think you can make a difference. You don't think being involved matters, and it really does. Donald Trump is exacerbated. The reason you see my second bullet point there, toxins in the permafrost. I love to use this example. Isabel Wilkerson is the author of a book called CASTE, C-A-S-T-E, and what she describes is what was the virus that was released 20 years or so ago, the early 2000s? Anthrax. Anthrax. Remember, people started dying from this. Say it again. Yeah, it was anthrax. But my point is, just beneath the Earth's surface are different layers. You go down a few layers, there's a place called permafrost. And that's where a lot of diseases and toxins are buried. Through climate change and global warming, every now and then some of those toxins are released. Hatred is a toxin. Racism is a toxin. Violence is a toxin. All three are more prevalent today than they've been in most of our lifetime. And Mr. Trump is almost single-handedly responsible. He's that source of global warming. He's that source of climate change. He has made white racism comfortable with that attitude. So we're fighting a new fight. Are you telling me, and Black Lives Matter was born out of this particular, and I didn't have the courage to put Trump's face. That's why I just put that long sign up there. I was not going to put his face on one of my, you're welcome. So here we are. 2020 was a moment of convergence. First of all, what was going on in 2020, just 2 years ago? You see it right there, COVID, record voter turnout. We also talked about Black Lives Matter. When did the Black Lives Matter protest and demonstration begin to subside? Think about it. What was the single defining moment? Something happened all of a sudden. From the date that Mr. Floyd was brutally murdered all the way up to something, there was a protest or a demonstration every day, not only all across America, in 60 countries around the world. There were Black Lives Matter protests. When did it stop? No. Election day. Y'all get it? It was your power. It was election day. You ain't seen a Black Lives Matter protest or demonstration after election day. White folk were paying attention. Racism was paying attention. You hear what I'm saying? And y'all delivered in 2020. The African-American vote saved this American democracy. You don't realize your power. There were 9 battleground states that provided the margin of victory for Mr. Biden and Ms. Harris. And Michigan was one of them. You guys remember what happened on election night? The last bullet point. Remember all those mean-spirited people came to what used to be Cobo, which is Huntington Place? Livonia had more inaccuracies than Detroit. Nobody went to Livonia. All of that's voter intimidation. All of that's voter suppression. All of that says get back. All of that says get back. It was the African-American voter that saved this American democracy. In Georgia, they waited for what before they declared the winner of Georgia? They waited for which community? Atlanta. In Pennsylvania, they waited for who? Philadelphia and Pittsburgh. In Ohio, they waited for who? Cleveland and Cincinnati. In all of these battleground states, they waited for the African-American vote to be counted. Do you get that? I am suggesting we've got more power than we even acknowledge. But worse than that, we got power that we don't even use. And voting is absolutely your power. So I said all of that to say we got to take advantage of all of Michigan's new voting rights. You guys delivered new voting rights. These are they. No excuse absentee voting. 5.5 million people participated in the voting process in 2020. And 3.5 million participated via no excuse absentee voting. That's the first time in Michigan history where the script was flipped. All of a sudden, 2 out of 3 voters went via the absentee process typically is 1 out of 3. But because of COVID, people were a little more security conscious. Same-day voter registration, you should know 30,000 people registered and voted on Election Day for the first time in Michigan history. And if you really want to impact voter turnout, you need to start now. Don't wait until Election Day. We got 45 days now before Election Day to start driving people to the poll. But we still are begging and pleading. Chewy and Lori and Toy, we're hosting all these election protection training, how to be an ambassador, how to be a poll watcher. You know, we're knocking on doors saying, please go and vote. We've got the power. 250,000 people in Detroit went to the poll on 2020 on presidential election. Mr. Biden and Ms. Harris won Michigan by 154,000 votes. So who provided the margin of victory? It was the black voter in Detroit. I'm saying you got the power. And then everybody is aware that you've got automatic voter registration. That means every time you have an interaction with the Secretary of State's office, we're going to register you to vote. And why is that especially significant, though? Because young people really, that 18 to 35 demographic, that's our secret weapon. All of us should be working with young people some kind of way, somehow. We know scientifically that if a young person votes on the very first opportunity they get, or the second opportunity, they become what? Voters for life. If they miss that first or second opportunity, then it's people like us that spend the rest of our life chasing that voter. So I'm telling you that young voter is important. All of you, I would encourage you, get some type of relationship in high schools. Work particularly with high school seniors. Make sure that they're mock elections. Make sure that they're civics on Friday or something like that. We've got to make a difference. That's where our best hope is. And the last thing I want to just touch upon, then I'm going to be done, is, am I stuck again? Jermaine Pegues. I was there. I was doing pretty good. I was at number 9. Let's see what happens. Jermaine. Okay, here we are. Y'all notice our Democrat, our white friends in the Democratic Party have been silent on this issue? Have you noticed that, Brian? We're at a critical place, y'all. We just lost. We just lost. And I use Marshall Bullock versus Mallory McMurrow just as one example. Marshall Bullock's district used to go down. This is Detroit now. He used to go all the way down to Southgate and Allen Park. They shifted the whole district, and now he went as far north as Birmingham. Mallory McMurrow lives in Royal Oak. That city that went from 3% black to 1.5% black as per Steve. Right?
I didn't give you the rest of that story.
I know there's more.
One of the city officials said to me, well, what are we going to do with our analysis of impediments because we don't have a problem in our city. Right after he said about black population going by half, he said, well, we don't really know what we would have to address. Like, what?
Yeah.
Did you hear what you just said?
Yeah.
And you didn't see that as a problem?
You didn't see that as a problem.
I'm just so stunned. I didn't know
So one of the things Cliff Schrupp and I used to talk about is the need for welcoming cities. You have to educate city leaders how to become welcoming. As the demographics begin to change, there are things you need to articulate. You can't be silent on police violence. You can't be silent on schools that don't celebrate Martin Luther King or acknowledge Black History Month. You can't be silent. Your demographics are changing. But those are elements of a welcoming community. So this ain't personal. This is just a reflection of our commitment to self-determination. If we don't get this right, African Americans used to have opportunities to win 10 seats in the Michigan House, 5 seats in the Senate, and 2 congressional seats. That was 17. Today, we're lucky if we wind up with 5. You hear what I'm saying? 17 to 5. We're not talking about this. Our friends in the Democratic Party, they chose safe Democratic seats over African American seats. And you tell me if an African American elected official and a Democrat, are they the same people? Brian, you were going to jump in?
The one thing that disturbs me the most about Marcus Lewis, I appreciate you using him as an example. Our state legislature, our Detroit caucus and our Michigan legislative black caucus is going to look a whole lot different. I don't think a lot of people understand what that looks like till that group is seated in January 22. And he was the sitting chair of the legislative.
He was the sitting chair of the legislative black caucus. So all I'm saying to you guys, let's be honest. If we don't tell the truth and speak truth to power, then we're dwelling beneath our privilege. We just suffered a major loss. And let me just do this on a personal note. You know that I served as Assistant Secretary of State for 3.5 years alongside Jocelyn Benson. I still work with her on the political side, and I like certain things about Jocelyn because she's a smart white girl who gets it, and she talks very openly about her commitment to civil rights and social justice and democracy and fairness. She gets it. It was easy for me to step aside because I didn't like what happened here with this redistricting racism. 4 years ago, I was an advocate for this. Then I saw how this thing played out. Black people don't get the benefit of crossover voting. Y'all vote for white folk all the time. And the reason I know that specifically is because I also had the opportunity to serve as campaign manager for Adam Ollier. He came in number 2. 19 communities. Mike Mendez was with me. Brian Love was with me. Half of you were with me. But my point is, 19 communities. Guess how many of those 19 communities did any African American win? 0. How does that happen? Sharif Anadar came in number 1 in all 19 communities, including Detroit. Now, there's a flip side. Our hands are not clean either. There were 8 African Americans that ran. 6 of them should not have run. 6 of them should not have run. But that still doesn't absolve a guy like Shree, in my opinion. Shree was an opportunist. He was an opportunist. He was an interloper. He manipulated a moment. How many votes did he get? Anybody know? What percentage of the total vote did he get? And you guys are front line. If you sit in a meeting like this on a Saturday, you're on the front line. He got 28%. That means, what that also means, the flip side, that means 72% of the new 13th congressional district did not vote for this guy. So does he represent our interests? Did he have any obliged to represent our particular interest? So, yeah. Add to it. Ooh-wee. 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 So I love you, Chewy. You're deeper than me, bro, because that is so true. So the African-American struggle for self-determination has been violated when a millionaire outsider can come in and spend $6 to $8 million to exploit the so-called democratic process, which allows for a simple plurality to achieve victory. So what am I saying there? First of all, if you don't get 50 plus 1% of the vote, there should be a runoff. So we got to change some laws. We should never allow that to happen in our community again. Somebody can come in and win 25, 30% of the vote and represent us for the next 2 years. What happens if he takes office on January 1 and on January 15, a black boy is going to get killed somewhere in the streets of the 13th Congressional District, and he's our representative? What do you expect he to say? What do you expect him to say? You talked about lived experiences. What do you expect him to say instinctively? When we have a fair housing challenge like Steve described, and all of the evidence is put on the table in front of Shree, what do you think he's going to say? He don't know what to say because his mama or his daddy or his grandparents have never been subject to that. It's not a part of his lived experience. So Shree did not win a majority. He exploited the rules. Most of the blacks who got in the 13th should never have gotten. They should have stayed away. They had no pathway. This is a new level of consciousness, Brian, that we have to continue to articulate. Pegues, LaToya, Lori. If you don't have a pathway, if you can't raise $100,000, sit down. Shut up. You got to say that to candidates. It's $1 million plus. It's really $2 to $3 million to win a congressional seat. If you can't raise $100,000 in the first 30 days after you announce your candidacy, withdraw your candidacy. You ain't got to respect Hester Wheeler or Warren Evans or Steve Bland or Wendell Anthony or people who are trying to do the right thing by pulling together a consensus discussion, use metrics. If you can't get the money, get out the way. That's a bottom line. So, wait, Jermaine, don't move. And I'm Hester Wheeler, and I approve this message. Thank you so very much. Thank you guys so very much. Any questions or comments? LaToya, I'm sorry. Yeah, you just did it. LaToya just provided a critical announcement, and that is especially important. The NAACP is a C3 organization. We don't make political endorsements. I'm a free man. I'm a citizen of the city, and they asked me to come and make comments about voting. I just said what I said. Yeah. So, Lori, go ahead. Yeah, that's it changes from community to community. Now, you do have to be very specific and very succinct about which race it is. Working with Adam, for example, I think we raised almost $3 million in about 8 months. But remember the way the census data, we didn't know what the districts were going to look like until early January. From early January to Election Day in August, we raised nearly $3 million. Guess how much money Jocelyn's already raised? $6 million. And we raised $3 million, but hers is a statewide, and she has a different national appeal. We've watched, Chewy, over the years, state legislative districts in Detroit, 15 to 25,000, you can win. But if you're outstate and more competitive, you might need 1 to 200,000. You see how they're duking it out with Kevin Hertel and Hornberger, and what's my man down, Camilleri. Man, they duking it out. They're fighting for those legislative seats. You've never seen that before, but that's an impact of redistricting. What did I say about Johnson? I said Jocelyn. Yeah, Jocelyn Benson. I'm working with her on her candidacy for Secretary of State. She really doesn't. What a tragedy, though, Tara. What a tragedy. And this is the last thing. She brought it up. Shoot, I was about to go to my seat. Herschel Walker is an embarrassment. Even John James.
But what do they all have in common? The 3 black people you just mentioned.
And you talking about Christina Caramel?
Herschel.
3 French fries short of a Happy Meal.
No, it's more than that.
What is it? What do they have in common?
All of them, each one of them, have been dug up out of somewhere by Donald Trump.
Yes, sir.
Every one of them. Yes, ma'am. That's not partisan. I'm not partisan. Anyway, thank you, Hester. Great message. Great message. I want to mention the fact that you have had over the last 4 weeks some great presentations. Every one of them have been free. You ain't paid a dime to hear Hester Wheeler, Steve Domkowiak, anybody. And this is really superior stuff that you're getting. This is college level training. If you enrolled at a community college, you'd be paying thousands of dollars to hear this. It's all brought to you at no expense to you by your Detroit branch NAACP. You keep that in mind. And the reason I'm saying this is because somebody in my neighborhood, African American, asked me the other day, what's the NAACP doing? And I emailed to them the e-blast that LaToya so faithfully sends out, LaToya Henry. Great job. And it was like several pages long. That and this is what the NAACP is doing for you. Now it's time for the NAACP to do it with you. And so every one of us has to be an ambassador. No matter where we come from, no matter what we think, we got to go out now and start talking about mobilizing people, getting them out to vote. Not how they vote, but vote. That's what we got to do. So thank you all for coming. Appreciate it. Questions? If you have questions, I might have answers. Look. Yes, that was what I was supposed to do, wasn't it? Yes. Well, you know, elections, like Hester just talked about, are very, very important. In fact, LaToya, you come on up here and do it. And this afternoon, we're going to have challenger training over at the UAW Vote Center on Livernois, just south of Finkel, in which we're going to train folks how to watch out for efforts to steal the election. Challengers are very important people because we're going to have a whole bunch of people who don't live in this community, who never even set foot in this community, coming in here trying to dictate what's going to happen in this election in Detroit. I was in the well, it was TCF then. Now it's Huntington Place. The glass almost came out of the windows when those folks were banging on that window, talking about stop the election. I mean, it was the only other time I saw something like that was in 1967, when the city was on fire. And I thought maybe the city was on fire. As we sat in Huntington Place, I'm thinking maybe the city's on fire outside, because that's the only other time I ever saw a riot was what was going on by people who had no involvement in the city of Detroit. And it's always so interesting to me that the only place where they found that there was any discrepancy in terms of electioneering and voting and counting ballots was in an all-white community up north. Antrim County, the only place, nobody went up there and banged on any windows. The only place where it was documented that voting machines weren't accurately recording the vote. So come on. We know we got to face these challenges and we got to be ready. LaToya, come on, tell us about the rest of the, come around this way so you don't get over that cord.
Good afternoon. I will utilize the mic because I am conscious of those who are on the stream and Zoom. So thank you on behalf of our president, Reverend Dr. Wendell Anthony, and our executive director, Camellia Landrum. Thank you for participating in the George W. Crockett Jr. Community Law School. This ends today for 2022, but we have several events coming up that you can become engaged with. First is Tuesday, we are having a school board's candidates fair. There are 4 seats open for the Detroit Public Schools Community District Board, but there are 18 people running for those 4 seats. So this is your opportunity to come and meet the candidates. We also have a little incentive for the first 100 attendees. We will have a $50 Visa gift card, so don't worry about gas or anything else to be able to get to that event. We will be at the Horatio Williams Foundation. If you're watching via streaming or on Zoom, please go to our website. The flyer is up, DetroitNAACP.org, and register today. Thursday will be our general membership meeting. It will be virtual. You can also register for the general membership meeting via our website. It is at 6 p.m. And Friday, our youth council, the Detroit NAACP Youth Council for youth aged 12 to 18, will be having a haunted open house here in the building. That's free, that's fun. It's a way for youth to come out, get engaged, learn about the youth council. We'll have a DJ, treats, all of that. We'll have prizes and giveaways for them. That's also on our website. And Saturday, the 29th, is our next Challenger and Poll Watcher training. So if you cannot make it today, it will be at the UAW Vote 1A Center. Sunday, October 30th. Nope, I haven't stopped yet. Sunday, October 30th is our Super Sunday at several churches. We will be in the community reminding you to take your souls, S-O-L-E-S, and souls, S-O-U-L-S, to the polls. And Saturday, November 5th, is our party at the polls. We will start here, 10 a.m. We will meet, gather, and march to the Department of Elections for those who would like to vote early. Additionally, if you go to our website, DetroitNAACP.org, you can see the locations. If you click on the Take Your Souls to the Polls icon at the top, you can see the locations for the vote centers and the ballot drop boxes. So you do not have to wait. As Hester said, you can vote now and you can direct others to vote. And finally, I would be remiss. We said all of this is free. We're in this lovely facility, but please go to DetroitNAACP.org/join and get a membership, because membership has its privileges. Thank you and have a good afternoon.
See, I told y'all she could do a better job than me. So thank you all for coming. This law school happens every year around this time. Thank you for coming.